Okay. Stuff with the wires. Okay. So we're in a public meeting format to begin with. We had the pledge, so we'll have a roll call. Do we have Suzanne on yet?
She's on here, but I'm not sure that she can hear.
If you can hear Suzanne, indicate somehow, either raising your hand or whatever, that you're here. Oh, well, anyway, so we'll take a roll call.
Can you hear me?
There we go.
Can you hear me?
Hi. Yes. Can you hear us? That's the question. Anyway, I'll take it that she says she's here. Okay, from my left then.
Commissioner Linscott.
Commissioner Reed.
Commissioner Bailey. Commissioner Bradish.
And Commissioner Davis presiding. We do have a quorum. The agenda, we have no written changes in the agenda. However, I would like to bring the last item on the agenda is the workshop for the mining ordinance. I want to bring that forward just for a minute. First off, to see how many of you are here for the mining ordinance workshop. Really? Well, that's a surprise.
He went down looking for you.
Okay. All right then. So I just wanted to go through that and explain what's going to happen. But if everybody's here for these files, then fine. We'll just proceed, go back to the regular agenda. So the consent agenda, don't have to change it. Okay. And the first thing on the consent agenda is the approval of the minutes from August 6th, 2020. Has everybody had a chance to look at those? Any need for changes in the minutes? Everybody satisfied with it? Okay. I'll sign them off and declare that they are okay. Okay, so that finishes our consent agenda and the public meeting format. Now we're in public hearing mode. And we have 1, 2, 3, 4, 5 cases, 5 files to consider at this 5:30 hour, however long it takes. So I'll introduce the first file. The file is V0013-20 side yard setback and shoreline exceptions variance for John and Patricia Wayne. So on the screen is our process or procedure, and I'll go through it. The staff report is made first. Applicant provides an overview of the project. Applicant or applicant's representative. Then there's public testimony. As it says, support, neutral, or opposition, but really whatever you want to say. And as it says, public testimony, in light of tonight, we got a lot of things to do, so let's see if we can keep our comments to 3 minutes. And if you have any exhibits, you can give them to staff so they can be numbered and entered into the record. So once the public testimony is done, then the applicant can respond to the testimony if necessary, if they feel it should be done. And then once that's done, there's no further public testimony. We don't go rounds and rounds and rounds. We just have the presentation and testimony and rebuttal. And that closes the testimony portion, and the commission deliberates the file. So first thing with this file, any conflicts of interest on the part of the commission on this one, or any other thing to divulge? Okay, hearing none. And like it says up there, the first thing is the staff report. So please proceed.
Okay, thank you so much, Commissioner. So my name is Amanda DeLima. I'm staff planner with Bonner County Planning Department. I think that Commissioner Davis did a good introduction for the project. We've got multiple requests for this variance. We're looking at a side yard setback variance, a walkway width variance, retaining wall height variance, and an impervious surface variance. The applicants are John and Patricia Wayne, and we have a project representative, Jeremy Grimm, here from Whiskey Rock Planning and Consulting. So a little bit about the site. This is an aerial of the site that we are going to be analyzing tonight. It's a residential site. It's platted. It's an old state subdivision, Booties Point Second Edition, Block 1, Lot 1. The site is approximately 1 acre in size, and it's zoned Forest 40, and it does not have a land use designation. The access is off of Cape Horn Road, which is a privately maintained gravel road of unknown ownership in the Bonner County map. Some environmental factors about the site, as you can see on the map, it does contain 15% map slopes according to our map. There is some floodplain on the bottom portion of the lot, bordering the lake, and it does contain frontage on Priest Lake. We routed this for comments to the floodplain manager, and he did comment back in June that the parcel does have a combination of floodplain as well as areas of the property that are not in the floodplain. And some of the work that was done, he said, may or may not be in the floodplain, and that should be examined at the time of building a permit when we get through the variance. So I'm just going to kind of go through and itemize the list of requests so that we can understand what's being asked. So as I said, one of the requests is that we're looking for, the applicant is requesting a 2-foot 8-inch side yard setback where 5 feet is required for their zone. They're also requesting a 6-foot 2-inch retaining wall height variance where 36 inches is the maximum in the shoreline. And then we're also looking at a walkway width variance as well as an impervious surface variance, and we'll get into what these look like for the site. So the first one is the pathway width variance. This is a picture of the site. Staff visited the site with a project representative, and we measured varying widths anywhere from 4'10" to 5'6" respectively, where 4 feet or less is required within the shoreline setback. We also have a shoreline retaining wall variance. According to the applicant and measurements taken on site, it's about 6'2", where only 32 inches is allowed within that shoreline, within 200 feet of the shoreline. We also have an impervious surface variance. The applicant states, according to as-built plans, the site contains approximately just over 15,000 square feet of impervious surface. On the 2017 building location permits that were a part of the development that happened on the site, only 10,000 square feet is allowed for this site. So we're looking at about a 54% exceedance of the standard. And then the last portion of this request is the side yard setback variance. So as I stated before, we've got 2 foot 8 inches into the setback where 5 feet is required. This is a photo of the accessory structure, which has been called an art studio throughout the building location permit process. And we took these measurements on site, pulled the string from the pins that were marked as a part of a survey, and we came up with 2 foot 8 and 8.5 inches. So they're really looking for an as-built variance here. So this is a photo from the approved building location permit from 2017. In 2017, the applicants did apply for building location permits to do all of the existing improvements on the lot. This is specific for the art studio. Back in 2017, it was approved for a 10-foot side yard setback. I think at the time, maybe they were looking to have a little bit of space there on the side in case they wanted to use it as an ADU or something like that. So 10 feet is required for dwellings, 5 feet is required for accessory structures. So that's why this request is for 5 feet and not 10 feet as the approved building location permit from back in 2017. So variances have three review items. So the first review item is to have staff examine whether conditions apply to the property that do not apply generally to other properties in the same zone or vicinity, which conditions are a result of either lot size, shape, topography, or any other circumstances over which the applicant has no control. So the applicant stated there was a long narrative because we do have these 4 items we're looking at. So I'm just going to kind of break these down for condition A. So for condition A, we're going to look at the pathway width variance. The retaining wall variance. So the applicant had responded that the subject parcel slopes steeply, averaging over 21% towards Priest Lake. And as a result of the design and construction of the retaining walls and pathways, it required some additional flexibility to avoid the construction of switchbacks. So that was their response to condition A. As designed, the basalt rock placement ensures robust slope stability, which prevents erosion and slumping. The determination that the basalt rocks constitute a wall or structure exceeding the 36-inch height allowance within the 40 foot of the shoreline could be arbitrary, as the stones are not placed in a vertical plane, a defining component of a wall according to the American Planning Association Dictionary of Planning Terms. So staff went in and we provided analysis based off of the information given to us by the applicant, as well as the items we had on file. Staff concurs that the applicant does not have control over the slope on the property. Per the county map, the slope is identified between 0 and 15% across the parcel. Accordingly, a taller wall may be necessary to stabilize a slope below the house, depending on the style of the foundation associated with the home that was built. So the applicant also responded that in order to mitigate the steep slope, the design of the pathway to the water incorporates a slight increase in width to allow comfortable passage for two individuals walking together, which is especially necessary for those with age-related vertigo or other handicaps which necessitate assisted walking. Staff did analyze this. I went into the ADA requirements for pathway widths, and the Bonner County Revised Code allows for a 48-inch pathway width within the waterfront setback, which is ADA compliant. And they require actually a minimum of 36 inches. So for safe handicap access. While the Bonner County Revised Code may be compliant with ADA requirements, the applicant states that the paths are 58 inches wide for individuals to walk side by side. For these conditions, the commission may grant relief from the strict application of the provisions of this title. So it's up to the governing board to decide whether or not that is adequate for this situation. The applicant also responded that in an effort to provide the best possible slope stability and erosion prevention, the property owners chose to install the massive basalt blocks which blend in well with the natural surroundings. In essence, this goes on to say that those basalt rocks do contribute to the impervious surface nature of the site. So staff did take a look at that information, and we do have on record, 3 permits, one for the house, the garage, and the art studio. So we were able to go back and track that impervious surface worksheet that we require for sites building within the shoreline. While the project originally required this professional stormwater plan, Bonner County Revised Code does not allow stormwater drainage to be a substitute for additional impervious areas, as stated in this narrative statement. While the applicant states that basalt rocks have added to the impervious nature of the lot in general, the records do show that the walls were included in the shoreline worksheet with all 3 permits. So they were aware of the 10,000 square feet at the time of permitting, and the exceedance is on top of that. So the last portion of this condition is examining the side yard setback variance. The applicant didn't speak directly to the side yard setback and whether conditions do apply to the property that do not apply to other properties. So staff went in and analyzed this. Staff has examined the evidence provided with the application to determine whether a hardship exists in the case of the art studio that would require an encroachment into the side yard setback. Bonner County Revised Code does require an examination of whether or not those conditions do apply to the property that would cause that hardship. The applicant has simply stated that they would like comprehensive relief from this piece of code, while not necessarily providing a reason for it. While slope has been used as a justification for an increase in the retaining wall size, a site visit did show that there is not a slope constraint causing that building to be slid and encroach into the side yard setback. Additionally, it should be noted that in Title 11-124, it states that it shall be lawful for any person, firm, or corporation to do, cause, or permit to be done, whether acting as the principal agent or employee of any construction, that they are acting upon the actions of the landowner. So we did have some information in there that said that the contractor did build this structure out of compliance with the permit, and that the applicant did not know about this. So I just wanted to say that Title 11 does talk about that. So the second standard is whether or not special conditions and circumstances do not result from the actions of the applicant. I'll try to move swiftly through this one, because the applicant actually used the same response for A and B. So I just went in and looked at the code and examined and analyzed from this vantage point of whether or not granting, oh, I think I skipped one, or whether or not special conditions and circumstances do not result from the actions of the applicant. Records show that the applicant did develop the existing structures through 3 building location permits in 2017. The applicant was notified when the property was being developed out of compliance with the open permit, specifically for the art studio. We have 3 violations on the property, 2 are zoning violations and 1 is a building violation, of which a stop work order was placed on the property. While some attempts were made to remedy the setback issue on behalf of the landowner, these violations still result from the actions of the applicant or someone acting on behalf of the applicant. So the last standard review is whether or not granting the variance is in conflict with public interest. We simply route to agencies and neighbors to see if there are these conflicts in public interest. The applicant did say that several of the requested variances mentioned above are likely able to be mitigated through this administrative relief provided by Bonner County Code. In an effort to provide comprehensive relief and transparency to approach the alleged violations holistically, the property owner has chosen to seek a variance through the Planning Commission Board and the Board of County Commissioners, whereby additional flexibility to the standards may be granted. So they go on to quote the code and talk about how they would like that comprehensive relief from these violations. So we did route to agencies. This is a part of our process to answer letter C. We routed on June 16th to the following agencies. We did receive some comments as well as some no comment responses. We did receive a comment from the Idaho Fish and Game on July 8th. In summary, I know that the commissioners have this letter, but in summary, Fish and Game found the exceedance of the impervious surfaces to be the most concerning. Priest Lake's fishery is primarily focused on salmonids, which require a high level of water quality to thrive. If variances to county code are regularly allowed for and lead to increased nutrients inputs into the lake, declines in water quality would be expected to negatively affect the fishery. Fish and Game is recommending that the county verifies the mitigation measures for additional stormwater runoff if the variance gets approved. So we also routed within 300 feet of the subject parcel. We received 4 public comments from neighbors. We do have those letters in the record that were attached with the commissioner's package. And so all I did was summarize them here in this PowerPoint. So from Lynch, one of the neighbors, they replied that regulations are a matter of public information. It is the Wayne's responsibility to adhere to local ordinances. The request should be denied in effort to encourage contractors to abide by the rules and to discourage the overreach of law. We also received a comment on August 13th on 2018. Oh, sorry, that was their letter. On August 13th of 2018, Mr. Rice said that Mr. Wayne was issued a stop work order by the Bonner County Planning Department because he was in violation of approved building location permit, which provided for a 10-foot side yard setback. Mr. Wayne either knew or is charged with knowing the regulations. These conditions are a result of the actions of the applicant, and this request should be denied. We also received a comment from the Gallaghers. Their letter is very lengthy, so this is my best attempt at summarizing their letter. Essentially, what they responded with is that the Wayne's variance isn't based on arguing the interpretation of a single code or regulation, and they have provided no legitimate reason for any of their infractions. And they do not have a single issue, they have several. They did not adhere to the plan the county approved. They built what they wanted where they wanted it. Now they're asking for the county to waive the violations. We categorically object to the Wayne's variance for a variance. The Wayne's request for a variance because they do not meet any of the variance standards. There are no building hardships due to slope or removal of the previous cabin, as all lots share similar features. The site is large enough to accommodate 35% impervious surface standards, as it is the largest lot in the subdivision, and neighboring lots have built homes on smaller lots without the need for a variance. In addition, the encroachment of the art studio imposes a threat to the safety of the adjoining property should a fire or other disaster occur. This violation is a life safety issue, and the county should not bear the responsibility should this get approved. And then the very last comment, and I do apologize for reading these slides, I just want to emanate the comments of folks that may or may not be here because they are important for the record and determining that last item in the variance standards. So this is the last one. These came from the Veets. I'm probably saying that incorrectly. They stated that we do not plan to call into the Wayne's public hearing on August 20th, but want to provide input that may pertain to the impervious surface variance. We are the Wayne's next door neighbors to the south. We are very concerned about the overbuilt lot and the type of landscaping that was done. We suspect runoff of fertilizer, chemicals, and silt into the lake. There also seems to be more silt in our water as evidenced by my sediment filter needing to be changed every 5 to 6 weeks versus a year. We are 100% dependent on lake water for our drinking water, bathing, cleaning, etc. We would like to see the appropriate Bonner County agency inspect and test the Wayne's property to see if they put in functioning catch basins and to ascertain whether various runoff is in evidence. Anytime we have voiced a concern directly to the Waynes, we do not get a reply and we come away feeling that they do not want to bother addressing these issues with their neighbors. They go on to talk about a driveway encroachment, which is not necessarily within our purview, but subsequently we suspect that the Waynes drain field is encroaching on their parcel of land, and they would not be surprised if there are more violations that should have been caught during the building process. In essence, staff has reviewed the standards and responded with the analysis provided in the staff report and during deliberation. At this time, staff does not offer a recommendation for this project as a whole, as the governing body may choose to analyze each request individually, as this is a complicated variance. The final decision does rest with the governing body after the completion of the public hearing and consideration of all relevant oral and written testimony and evidence. There are 3 conditions I placed upon this variance based off of feedback I received from some of the agencies, as well as internally due to floodplain. So with that, thank you. And do you have any questions for staff?
Questions for staff?
So was the stop work order issued during construction and they continued construction?
Yeah, so it was a tricky one. So there was a stop work order as the art studio started to be built, and I believe that they adjusted the art studio. They moved it because it was either on the property line or too close. And then during the adjustment process, as it was being built, it was found that it was still out of compliance with the setback. I think that the property line has been surveyed a few times according to the record, and I know that the applicant can probably speak more to what has happened over time with the property line. And those circumstances, but they were issued a stop work order. Yep.
Okay. Any other questions for staff?
Yeah, do you have
Commissioner Glass.
topography?
Just a minute, Suzanne. We got a question going.
So,
Go ahead.
Okay, so,
So do we have elevation shots
yeah,
of the topography?
a topo map so we can take a look at that whole area?
Yeah, so I have the best topo map that's available to me, and that's going to be this one, which is from the Bonner County map. So the pink shows that there's 15% slope.
What's the next one?
Yeah,
The one that had the grid lines in it, the survey map. Yeah, you had it. Yeah,
Oh,
There you go.
yeah,
So that shows topography.
somewhat.
that was their original.
There's site plan.
You mentioned that whole area up there is sloping. There's, I mean, that's typical of Priest Lake.
Yep.
So many sites that steep.
Okay, any other questions for staff?
Susan.
Commissioner Glasso.
Go ahead.
I don't know if you're speaking really fast or if I'm hearing really slow, but I want to really understand this. When they put in for their permit, they were adhering to the setbacks. When they actually put in the work, they violated that. Is correct?
That is correct.
Okay. And that was done upon their direction to their contractor and agreement.
Perhaps that would be a good question for the applicant. As far as from my vantage point as staff, we had an approved building location permit. At the time of inspection, it was found that the structure was built out of compliance with the approved permit and that there were other improvements on the lot that were not disclosed on the permits. Henceforth, the landscaping and the walls. Yeah.
Okay, so it was a clear violation. Thank you.
Okay,
Matt says,
Mr. Linscott?
Amanda, can you just briefly, I apologize for this, because we're covering a lot of different items here. On that retaining wall, the argument is that they were not stacked vertically on top of each other. They were set back. So what was the answer on that? Was it by the,
So it's an interesting thing. So I found that with this variance application, the applicant, they wanted to request a deviation from the code for the retaining wall while also saying that I don't think I need this request. So the only thing I can really speak to is the request itself. And so if you are requesting that the retaining wall be, grant alleviation from that height, all I can speak to is whether or not we meet those criteria. The Planning Commission may decide, well, maybe this is staggered and so we can grant this because maybe this isn't an issue to begin with. But to me, in order to apply for the variance means that you're admitting that the wall is out of compliance. So that's how I treated the application. If it was an issue, we would have sat down and we would have said, okay, your retaining wall is in compliance, so we don't need a variance for this portion. So that's how I treated the application. If you're requesting it, it means that you're admitting to. And so I just examined it from that vantage point. Do you have any other questions?
Okay, other questions? Okay, thank you. So at this time, the applicant's representative would come up and name and record for the address.
Over here or anywhere?
Just at the podium.
Excellent. Thank you, planning commissioners. My name is Jeremy Grimm, professional planner and over at Whiskey Rock Planning. Appreciate your time tonight. Tonight represents what the applicant, Mr. and Mrs. Wayne, hope will be the conclusion of a very long and challenging project going back more than 3 years and involving the hiring and firing of multiple contractors, alleged experts, numerous issues, mistakes, complaint violations, red tags, stop work orders, and a whole lot of frustration. This project's been very challenging for the Waynes, and at no fault of their own. A number of improvements installed on their property failed to meet the standards of the code today. We readily admit that. We could have applied for individual administrative relief for some of them, but we wanted to be forthright and just get this all out in front because the house and the improvements are in place today. Throughout this project, Mr. Wayne has trusted contractors to do the right thing, and most of those involved believe that they were doing the right thing. Mr. Wayne's not an experienced builder, surveyor, or professional land developer. He's repeatedly directed those working for him to follow all rules and regulations. When made aware of errors, he has fronted the cost to redo work, remove foundations, and correct issues as requested by Bonner County. In general, Mr. Wayne has greatly improved this property in comparison to its previous configuration state lease lot. In fact, one result of his building project is that the previous leach field associated with the former structure was removed from being 75 feet from the water and then was relocated at great cost to over 1,000 feet away, improving water quality. Despite these efforts, the end result is in fact a new home, accessory building, and improvements that exceed several portions of standards from Bonner County Code Title 12. We're before you tonight to request specific relief from some of these standards in order that Mr. Wayne may move forward with the peaceful enjoyment of his home on Cape Horn Road, rather than venture into contentious and costly legal battles over fault and responsibility. We hope to show that through the opportunity granted to the variance request process, that the infrastructure and improvements as they currently exist do not harm the health, safety, or welfare of the public or adjacent neighbors. And further, that although some of the violations could likely be solved given enough time, money, and lawyers, the end result of these efforts would have little, if any, material impact on the overall environment or to the benefit of Bonner County residents. To be clear, we admit, after exhaustive measurement and documentation, multiple site visits from Bonner County staff, and despite the best efforts of those involved in the construction of these improvements, that one, there are 3 areas of the pathway to the water that exceed the standards of Bonner County Code 12-711B1, which require paths to be less than 4 feet wide. We feel that the areas where the standards exceeded is fairly minimal and improves the surface access to the water for older residents who may need assistance walking or balancing. 2, there is a portion of the retaining wall made of natural basalt rock which exceeds 36 inches in height, in violation of Bonner County Code 12.7.12a. We feel that the challenging topography, including steep slopes, necessitates the exceedance by supporting the hill slope and making possible the development of stormwater treatment swales which filter and slow runoff, which are directly below these walls. 3, the total impervious surface within 200 feet of the shoreline may exceed the 35% allowance stipulated by Bonner County Code 12.7.13. We frankly don't know. One challenge in satisfying the code revision is the subject that the gravel driveway and basalt retaining walls are considered impervious, and per Bonner County Code, these elements shall be considered impervious if they prevent rain and snow melt from being absorbed into the ground at a natural rate. However, no consideration is given in Bonner County Code to the fact that all water runoff resulting from these improvements is directed into vegetative stormwater infiltration swales, which slow the volume and rate of runoff to below the natural rate. I'll show you some photos in a second. I want to move on because you're being very generous with your time. The side yard setback for the accessory structure has been encroached upon by 2 feet, 3.5 inches on one corner of the eave and by a ½ inch on the same facade corner, but not along the remainder of the side of the structure. This issue is the result of a number of confusing and problematic circumstances which the contractor, working with Bonner County inspectors, attempted to correct. Due to an error, misunderstanding, or movement of the northeast property corner monument, the string which had been understood as by the contractor to be the property line moved, resulting in the original lot corner and the facade not aligning with what he thought was going to be the property line. This resulted in a 2-foot overage, which the contractor then dug up the foundation, moved the whole building back in the presence of the building official, and they all believed that the new location was correct. Clearly it wasn't. In good faith, all parties involved were working from what they believed to be the best and most accurate information available, but the end result was, and is, a portion of the eave is encroaching. We feel that Mr. Wayne had no direct involvement with this error and that they were not the result of his actions, and relief will avoid costly and unsightly modifications which will result in no material change to the health, safety, or welfare of the adjacent property owner. In closing, Mr. Wayne has gone to extraordinary lengths to do the right thing, follow the code, and hire the best available surveyors, builders, landscapers, architects in the region. The unfortunate situation that we're in today may be able to be remedied to strictly comply with Bonner County Code by sawing off a portion of the eave, chiseling up a portion of the pathway, extracting basalt rocks or raising the ground level below them, removing a gravel driveway and replacing it with grass. However, the cost, stress, and resulting legal challenge over responsibility and cause would be significant. We seek your understanding and relief as provided to this variance request and hope that you find support. Do you have the ability to pull up our original application by chance?
I do.
I just wanted to quickly show you these extensive retaining swales and the extensive stormwater treatment and fire suppression that has been installed on the residence. Yeah.
And feel free to zoom in and, yep.
So in this photo here, this is below this basalt wall. This is, it's hard to tell, but this is a fairly large retention swale that has a drain and filtration in the bottom. This is one of numerous swales on the property. Here's another retention swale adjacent to the driveway, the gravel driveway, and you can see there's a cut in the curb. So all that runoff goes into the retention swale. Again, this is another retention swale adjacent to the property and the basalt wall. You'll also notice there's a fire hose. The applicant will just mention briefly after this, the incredible pump system and fire suppression system this property has. In fact, it exceeds anything I've ever seen in Bonner County. This is an example of another detention and retention swale. You can see the drain in the center there. But again, to blankly say, Fish and Game's comment that, runoff is a concern, absolutely, we get it. But if you were actually at the site and saw these improvements, you would be astounded by the responsibility and quality of these stormwater infiltration areas that Mr. Wayne has had built there. So moving on, I'd just briefly like to ask that Mr. Wayne have a moment just to speak to you here. And we also have representatives from Alderwood Landscaping and North Idaho Builders who can provide their perspective. North Idaho Builders was the second builder on the site after the original builders were fired or removed from the site due to incompetence. I would certainly answer any questions at this time or later as you see fit, Mr. Chairman.
So questions for Mr. Grimm at this point?
I do have one question. Jeremy, on that, the roof on that art studio, how much of it is sloping? Okay, you can see right there. Okay.
So it's a hip roof, so
Yeah, and it's just it's cockeyed. It's just the corner that's closest to us in that photo that's exceeding to the greatest degree, but it's kind of tilted on the property line. It's not a straight cut.
okay, any other questions? All right, so none right now, so.
Can Mr. Wayne come up and just give you a moment?
Yeah.
Mr. Wayne, would you like to just give your perspective of this ordeal?
I don't have a whole lot to say other than what my intent is and was all the time. I bought that property in 2016. I went out and I hired a contractor. I hired that was up Priest Lake. And then I hired a architect here in town, Hendricks Architect. And then I hired Sewell Engineering, that they did the engineering on it. And then I hired the people that did the landscaping after the house was put up. At no time, at any time, during that construction process, did I give anybody any instructions to or push for them to do anything out of line or anything like that. To the best of, I think, everybody's knowledge, but I know to my knowledge, we were doing it the way that it was supposed to be done based upon the plans that we had there at that time and the lot lines that we had. If it turned, I guess it turns out afterwards that the lot lines were maybe incorrect. I don't know. But what I do know is I at no time ever asked anybody to do anything that they shouldn't do or it would create a problem for the area out there.
Questions for Mr. Wayne?
Yes.
Yes, please. When you purchased your lot, you did that at auction, correct?
Yes, I did.
And JUB had surveyed all those lots.
Yes.
And they knew where all the easements, everything. They did a very detailed survey. Were you provided a copy of that survey when you
As a matter of
purchased?
fact, I was provided one which was incorrect. And I didn't even know that until after I had bought it.
Uh-huh. The lines weren't correct?
The
on
lines
it?
were not correct on what I bought. And I lost, I'm not swearing by this,
About
I
a
think,
fifth. I think it was about a fifth of an acre.
okay, on there. Ended up in one of my neighbor's yards.
Okay. Any other questions for Mr. Wayne?
Commissioner Glasso,
Yes. Go ahead, Suzanne.
I appreciate what I'm hearing that, lot lines were wrong or whatnot. Do we have any documented proof or anything that's been presented to suggest or prove that in fact it was going off wrong lot lines, or is it a matter of fact or just hearsay?
We have the actual contractor who was there when the lines were pulled and the new lines were identified. It's Brad from North Idaho Builders.
Okay. I'm also wondering about the staff. Yeah. Keep going, Suzanne.
I don't think my question was answered. There was a contractor on the line saying he relied on lot lines. where do you have the documentation tonight showing that lot lines were incorrect? You know, maybe his interpretation was incorrect. He's probably going to attest to that. I know that's coming up, but you're stating that the lot lines were incorrect. So where's the documentation supporting that?
Yeah, Suzanne, so this is Amanda, staff planner here. I'll speak to that a little bit. So the documentation would have been in the violation file, which isn't provided in the PowerPoint because they've already established that there was a discrepancy in the property line. So the intent of the variance, now that everybody is in agreement over where the property line is to remedy this setback issue. So I did not pull any of that. It would have been in notes from staff during site visits on inspections. And now that everybody's in agreement, we know that the structure is 2'8" from the property line, and they're requesting to grant alleviation from that. For 5 foot.
Amanda, I really, really appreciate that. Thank you so much.
Okay, so other questions? Great, thank you, Mr. Wayne.
Watch your foot there.
Yeah, watch out, we have wires strung everywhere. Okay. So
Commissioners, at your discretion, we do have both the landscapers and the contractors here. You know, I know you have a big agenda ahead of you tonight, so I don't want to go on at length, but if you have questions, they were there.
Maybe we'll do that. If there's a question, we could call on them to.
Are you guys okay with that? Do you feel like there's anything you really want to get on the record?
I don't know if you guys want to hear about the lot line.
Well, I think we've already established that it was recognized during the initial review and the stop work order, things were not right. Then came the survey and so forth, so that, like Amanda said, everybody's in agreement. That's the lot line now, and therefore there's a setback violation. So we'll go from that. Okay.
One other thing I'd like to say really quick. We were given
You have to identify.
Oh, sorry,
Mike with Overwood Landscaping, we're the landscape contractors that worked on the job.
Mike, what?
Mike Semrad? Sorry about that. So when we came to the job, there was a site engineering plan that was done to stop stormwater from going in the lake. And it's included in the documentation that's here. We put in all those swales and did all that to make sure that that would all be retained. But to do that, we had to put in the walls the size that they are. So there's steep slopes like we were talking about. And there's one area that goes above that side of the slope, but we had to put those in to be able to put in those swales and the landscape areas around that. So it wasn't we just wanted to put in higher walls. It was we wanted to make sure that we maintained that plan and make sure that all the stormwater was captured as per the original stamped engineering drawings. So I think it's
Okay,
important.
so that's addresses the reason why the wall is the way it is. Okay. So any other questions for the folks who did the site? We're still in owner's testimony here, so all right. So okay, so you're finished with your presentation. Okay, therefore, now anyone here who wants to comment on this file, please come forward to the podium, give us your name and address, and
Sure.
and watch all the wires and other stuff. We get an obstacle course.
You want to come up or?
Okay.
First of all, my name's Tom Gallagher. I am the neighbor to the north of and who share the property line with the Waynes. I want to talk about the side yard setback, but I got to set the record straight on the property line. I do understand that there was an adjustment made to their property line, but it wasn't this property line that we share. The adjustment, to my understanding, was their south property line, which has not been an issue of discussion tonight. Okay. So our current address is 4041 232nd Avenue Southeast, Sammamish, Washington. However, we are in the midst of building our home at Priest Lake, and today it's been permitted, and we're in the foundation stage of construction. As neighbors, our primary concern is the Wayne side yard encroachment of the art shed. The Waynes deviated from the 10 feet that was originally approved by the county, and they literally constructed the shed's foundation on our property, literally. During this stage, several friends and neighbors notified us. And after our visit to our property, we came down to the building here and we submitted a complaint violation form, which resulted in the shed being red tagged on August 13th, 2018. Only then did the Waynes move the shed several feet back to towards their property where it sits today. They cut off the exposed foundation wall and left the remainder of the foundation buried on our property. The applicant's original memorandum minimizes this encroachment and states an accessory structure encroaches into the 5-foot side yard setback by 7 inches. Well, we know that's not to be true. The Wayne's declaration contained no documented survey of proof, but it was accompanied by photos with deceiving hand-drawn property lines that favor this argument. I've included photos of what I'm talking about in my narrative. Now, conversely, I included an encroachment survey diagram dated March 27, 2020 of the shed's actual location performed by a licensed professional engineering survey company, James Sewell and Associates. It confirms the shed's location is 1 foot, 1.98 feet from the property line. Regarding public safety and health, the side yard setback encroachment presents a serious life safety hazard to our family, as well as endangering our property. The shed contains a wood stove with a chimney perilously close to our trees. Located just 1.79 feet from the property line, a structure fire would burn our neighboring trees and likely start our home on fire. The shed could literally collapse onto our property and set it ablaze. This is an incredibly serious condition they have created. In addition, the prevailing winds come from the Waynes towards us. A chimney in a shed located less than 2 feet from the property line creates increased smoke density and air pollution, which affects our air quality. Furthermore, steps down from the side of our patio will be just a few feet away and adjacent to the shed's existing location. The proximity of their shed to the property line results in a deterrent to use our home as intended. It is also an impediment to our view from the patio. For these reasons, we object to the shed remaining inside the side yard setback, again, currently less than 2 feet from the property line. In closing, all the Waynes violations are self-inflicted and all admitted to after the county inspection caught them. Nothing was brought forth beforehand. It should be noted the county has identified at least 4 infractions, not just a single unintended mistake made during construction. Multiple violations demonstrate significant ignorance or disregard for the county codes and regulations by the applicant. It is not acceptable to reward the Waynes with a variance for a series of egregious violations to the same rules and regulations everyone else is held to. The Waynes are solely responsible for their property, for those who they employ, and for correcting the multiple infractions of the county code. Appreciate the opportunity to speak, and I will gladly do my best to answer any questions you may have.
Questions for Mr. Gallagher? I do. Do you have a copy of the Sewell survey showing the one, is it 1.9 or 1.79 feet?
It's in my narrative.
It's in the letter.
It's in my narrative, and it's
Okay.
1.98 feet.
1.98.
Page 8. Under public comment?
Yeah.
It's a single page by itself.
Copies if anybody wants them.
I've made a lot of statements, and I've included photos in my narrative that hopefully provide you the clarity that was not included in the applicant's narrative.
The 1.95 feet, is that from the eave or the side of the house?
From the
From the eave. From the eave.
According to the survey. Any other questions for Mr. Gallagher? Okay, thank you, sir. Yes, would you?
Dawn, Dawn,
Yes, ma'am.
am I understanding something was just submitted and reviewed?
No, in the file, there's a letter, a long letter from the Gallaghers. Have you seen
Okay.
that? And that's where the.
Yes, thank you. I misunderstood. I thought there was something additional submitted, so I just want to review that. Thank you.
Yep, the survey is embedded in that letter, so copy the survey. Yes, go ahead.
Yeah, I'm Kathleen Gallagher. I just want to yield my time to Lisa. Oh, I'm sorry.
Okay, so Lisa, if you would.
Thank you so much. There are a lot of cords over here.
Yeah, it's kind of a obstacle course.
Artist, not touch that. Thank you and good evening. My name is Lisa Moline, M-O-L-I-N-E. I'm an attorney here in Sandpoint with Berg, McLaughlin, and Nelson, and I represent the Gallaghers in opposition of the Wayne's variance. I won't reiterate a lot of what Mr. Gallagher said as much as I can, but I do want to point out that survey. It's on page 8 of Mr. Gallagher's original objection that he filed on July 6th. And I would request that this board specifically find that that survey is the most accurate depiction of what actually is on the ground today and shows that the encroachment is actually 1.98 feet. And I brought it to measure because I think it's important to understand what 1.98 feet actually is. Sorry, Suzanne. That is what it is. That's how far away that property is. Property line is from that structure. And I think what I'm going to do is tie each of those 3 standards that you guys are required to find to the applicant's arguments, and then the Wayne's arguments and the Gallagher's objections. So I think I'll start with the first standard, which says that the conditions of the property that do not apply to generally the property in the same vicinity, and the conditions are a result of the size, shape, topography, or other circumstances which are out of the applicant's control. In other words, the size, the shape, the topography requires the Waynes to build that structure within 1.98 feet of the property line. The topography of the Wayne's lot is similar in shape and contour and slope to the other lots in that area, but specifically to the Gallagher's lot to the north. There is no uniqueness to the Wayne lot that would require that structure to be that close to the neighboring lot. And I think on page 2 of the Gallagher's opposition, there's a picture of the Wayne property when the Waynes purchased it from the Department of Lands. As you can see from that, it's the lower photo on page 2 of his opposition. And you can see from that photo that the slope is rolling, but mostly level. There's nothing in that photo that would indicate there's topographical features or any other circumstances that would prevent that artist studio from being built out of compliance. The Wayne's property is a large rectangle. It's not a crazy triangle that funnels to a point that would impede any building within the 5-foot setbacks. The Wayne had their engineer draft a map of the whole project in 2017, and we saw that map. It was the contour map, and it had that artist studio on there. It didn't show any impediments in the lot that would require that to be pushed over to 1.98 feet, other than the fact that they want to spread out their lot. See the view of the lake. I would also like to point out that this first standard says no other circumstances which are out of the applicant's control. That doesn't allow someone to decide they're going to maximize their building envelope. It indicates that the lay of the land requires it. And they have provided no proof that the lay of the land requires for that structure to be that close to the property line. Therefore, that condition has not been met. The second condition, and the most compelling one, which Mr. Gallagher already spoke to,
was the special conditions or circumstances did not result from the actions of the applicant. In other words, you must deny the variance request if the Waynes created the encroachment on their own action. This encroachment on the side yard setback requirement is entirely a result of the Waynes' actions. Mr. Gallagher mentioned earlier that the Waynes disregarded the property line on the outset and poured a foundation, to which that foundation still exists under dirt in my client's property today. And instead of moving it in compliance, getting a survey out there, making sure that that survey was ran all the way down the line, they just assumed this is where it is and I'm going to put my structure there. This is uncontested evidence that the Waynes had an opportunity to correct the error, and they didn't. They chose by their own actions to build within the setbacks. Therefore, the violation of this requirement is within the applicant's control, and the Waynes have unsuccessfully met their burden under this standard. The third standard is granting the variance that is not in conflict with the public interest or is detrimental to the health, safety, or welfare or materially injurious to property in the area. And this side yard encroachment creates a public safety and a welfare issue and is injurious to the surrounding properties, in particular the Gallaghers. Having a structure that close to the property line puts the Gallaghers' property at risk of fire. The chimney, it's a wood chimney, wood fireplace, is on the side of the Gallaghers' lot. Any sparks, chimney fires, or other hazards easily access the Gallaghers' property. There is nothing the Gallaghers can do to prevent such damage other than to remove trees on their side of the lot, which are mature, and I think you can see in this photo, some of them. You can see some trees that are hanging down in the overcap on the top. Additionally, there's barely enough room for a human to walk between the side of the eave or the structure and the side of the property line. Having a structure precariously close to the property line would require maintenance on a very consistent basis. Based on the Waynes' prior actions of pouring a foundation that later was buried, leaving debris and equipment on the Gallaghers' property during the construction, has proven that the Waynes have no respect for that property line or my client's property. And I think it's unrealistic to think they would respect that line now. And there's certainly no room for maintenance equipment, let alone a ladder. Based on the extreme hazard, regular maintenance would be almost impossible. And forcing the Gallaghers to continue to allow the Waynes to trespass on their property, absorb the risks, and accommodate is unreasonable and inappropriate. Last, the variance will interfere with the use and enjoyment of the Gallaghers and their property. This encroachment minimizes the Gallaghers' use, and their lot is substantially smaller than the Waynes. In order to accommodate their own building envelope, the stairs on the Gallagher residence walk directly down to that structure. And if there was a 5-foot setback, that would leave 10 feet buffer, which is a substantial amount. There's nothing that the Gallaghers can do to compensate for that. It is entirely unjust to make them accommodate their building envelope or their space or their enjoyment of their own property for an accessory dwelling on the Waynes property. In conclusion, the Waynes originally had an opportunity to cure the encroachment when they moved the structure from the Gallagher property. They did not do so. Instead, they're asking you to grant an exception to the detriment of the Gallaghers. It is unreasonable, and the evidence does not support an approval of this board. The Waynes failed to provide evidence that their lot was unique. They failed to provide evidence that the encroachment was not based on their own actions, and they have failed to provide evidence that this encroachment does not conflict with public policy. In fact, it creates a public safety issue. Therefore, we respectfully request this board to deny these variance requests. And of course, I specifically focused on the side yard because I think that's the most important one to us, although the Gallaghers object to all of them.
Okay, thank you. Any questions for Ms. Moline?
Ms. Moline, How far away is that chimney, that fireplace from the property line?
You know, I don't know that the Sewell and Associates actually surveyed that part of it. The survey's on page 9, and they don't. And I don't know if I would even venture to guess to
Right,
know
so-
how much that is.
How far is the,
Well, I guess where I'm getting at is that fireplace, let's say just argument's sake right here, they take that eave off that thing. If that fireplace is 5 feet off that property line, they're not gonna have to move that. So, go ahead.
No, go ahead, finish.
So I'm just thinking out loud here with that fireplace sitting right there, if it's 5 feet from that property line, I think they have every right to have it there. I don't know about the eave, we're gonna discuss that later. But if we're concerned about a fire risk from that chimney, from that fireplace, I don't even know if that's part of this discussion, because we haven't heard whether or not that's within that 5-foot setback.
Well, I'm not a contractor, that's for sure. So I would, I don't know the answer for sure, but looking at that description and not agreeing with the 2.85 feet, I don't think that eave is enough to bring it back, or even that fireplace. I would be shocked if that fireplace was 5 feet. I don't know that answer for sure. That's something that Sewell didn't address.
I see what you're saying. It's a bit of an angle and it's 4 feet something, if that's
Well,
correct.
That's not. We already established, or it's been stated that the 2.85 is actually 1.988. So that 4 point, whatever it says down there is in error according to the other testimony as well. So, okay, any other questions for Ms. Lane? All right, thank you.
Thank you for your time this evening.
Anyone else care to show their testimony? Okay, so Jeremy, if you want to respond, and if you would, one thing, just thinking it through based on what Mr. Wenscott was asking, the dimension of the eave from the face of the building. That's one thing we need to get.
We can probably get that. I'll get Brad up here in just a second. Let me just rebut a few of the elements that were brought up there. Thanks again for your time. First of all, the intent and the way this whole project went down, there was a mistake. There was no knowledge by Mr. Wayne that the original survey and the pins that were out there, that the contractors who started the job, those were incorrect. And the record of violation, as Amanda referenced, discusses some of those alignment issues. Secondly, this has no more weight than my drawn picture. In fact, my drawn picture, that's Amanda in the background, we pulled a pin from corner to corner, a line, and dropped a plumb line. What you'll notice on this is it doesn't have a surveyor or engineer stamp. This has about as much validity. This could be a document that, who knows what? Maybe this is a random draft that Sewell drew. We don't know. I'm not suggesting it's incorrect. I'm just saying there's really no clarity on whether this is a stamped engineer survey. It's a diagram as far as I think the record would show. Moving on, Mr. Wayne, as we mentioned, we could cure this variance with a chainsaw or other things. We're talking about 16 inches because under the code, we could have applied for an administrative variance of up to 30%, which effectively could grant us a setback going down to somewhere around an 18-inch encroachment. So the difference between the 18 and even if we want to call it the 2 feet, it's 16 inches. So could we cure it? Yeah. Is there going to be a material difference in impact on where this structure is and how the smoke comes out of the chimney that is clearly on the Wayne's property within outside the 5-foot setback? No. Is Mr. Wayne going to pay for it? Probably not. You know what? A bunch of small businesses who are trying their best to survive up in Priest Lake, who are working in the spring, the winter, you know, there's going to be litigation and correction and it's not Mr. Wayne probably who's gonna pay for it, it's small Idaho business owners who are trying their best to comply with the code, 70 miles away without anyone to come visit them on a drop of a dime. So yeah, mistakes are made. We're talking about 16 inches. And finally, they did move it. They tried to move it. When it was red tagged, just want to be very clear, the building official came out, Brad pulled the line, they realized there was an error, knocked down the foundation, moved it back to what they thought the appropriate 5 feet was, and it was still incorrect. And maybe that's the difference between building in Spokane or Seattle and on Priest Lake. It's sometimes hard to get things exactly right, and that's why the variance opportunity, I think, is there. So I would just ask Brad just to come up if you can speak briefly. They're wondering what the depth of that eve is.
Yeah, so the eave is 2 feet.
Can you state your name for the record?
It's Brad Ganger.
Okay, thank you.
The eave from the finish to finish, wood to wood, is 2 feet. With the gutter, it's probably 2 feet 3 inches. The math states that 4'11", 2'8". It's just over 2 foot. When we started this job, there was a line established there. The previous contractor got fired, and I can explain a lot of this, but that line was established. There was a pin. There was some, I should have done more research, but we went off of that line. The excavator who was working on that project stayed there to continue the work. He was the one who said, these are the points, this is where we went to. That's how that whole confusion came out. But at no point is the foundation on his property, even 4'11", we don't have a 5-foot footing encroaching on their property. We wouldn't pour that much cement. It's a small 16-inch footing that obtruded, and after we cut it, we cut 2 feet back. The footing that's underground is still there, and it's 2 feet from the property line. Even if the survey is whatever, it's still not on his property. I just want to clarify that. And
Thanks, Brad.
yeah,
That's all.
No.
Certainly entertain any final questions you have. I know we've got a lot to digest there.
Okay, any further final questions? All right. Okay, thank you, Mr. Grimm.
Thank you.
Okay, so that's testimony and rebuttal. So we'll close the testimony portion and open up for deliberation. Yeah. Whether you want to, as staff suggested or commented, handle these one at a time or in total, whatever.
Well, let's start with the walkway. Our code says 3 foot. Federal ADA says 4 foot. Yeah, so there's a little bit of leniency there.
Okay.
It's the opposite.
But ours is 4.
Yeah, sorry.
Well, actually, we do everything in town here, minimum walkway is 4 foot. Although I don't know the regs for the shoreline.
It's the same in Bonner County, correct? Yep, sorry.
We're on the same-
Yeah, it was just backwards. We have it the same way, same regs as in town.
That's 4 foot. All right. Because I thought I saw 36.
That's what the ADA recommends. That's their recommendation. And so we have 4 feet. We have an exceedance of what the ADA recommends.
30, yeah, but that probably is old because it's all 48 inches now. It's
Oh,
48.
okay, gotcha.
In the approach.
Anything that takes the wheelchair is
Right,
48.
right,
2 feet of casting.
which is what the code
We don't have
has.
current. Well, under office. What are building codes?
Okay, so further discussion about the walkway.
Here's my thoughts on this walkway. I can't help but think the reason for the walkway is because it's sitting within the 40-foot setback, is that correct? Right. And I imagine what we're dealing with there is for stormwater runoff for impervious areas being that close to the water. You're allowed 35% within 200 feet. However, the closer you get to the lake, I understand that. With all the swales that they place on that property up above to mitigate a lot of that impervious area, you know, I appreciate that. I don't know what to think about that retaining wall, especially if it's not lateral. Is it truly a wall? I don't know.
Did you see the letter that was written to?
Which letter?
Yeah.
I thought I read all of them.
Well, one of the question, they impervious area ratio.
Oh.
They,
It's 14.
they exceeded.
Right. Right, I understand that they exceeded that impervious area. However, I guess one of my questions may be for staff is on that stormwater plan, were all those swells included on that, on their stormwater plan?
As far as I could tell, they were, but the stormwater plan did not include the additional impervious surface. So the calculations for the swales aren't exactly incorrect because none of the paths or anything like that was disclosed. So one of the conditions of this variance is that they just give us that updated plan because it sounds like the map's been done and it's all in place, but we just don't have it on file. So I can't confirm that they're exactly matching because none of that landscaping work was provided at the time of permitting.
Okay. Let me just drop down blocks here. On the side.
Mr. Linscott, you have any more to say about that?
No, I was just trying to find some of the stuff that Cheryl has on her computer. I'm trying to find out where she found it. I know I wasn't very clear on my thoughts there, but it just questions in my mind that I was thinking.
So let's keep it moving.
All right, go to the accessory building, I suppose. They knew they had a problem when they removed the foundation. Why didn't they bring in a certified surveyor?
Very good.
It could have been answered then succinctly. And testimony was we thought we were in the right place. So, plus, even if the eave was cut back to the face of the building, it's still not in violation. It's in violation. It's not 5 feet from the property line. We want to say the property line as shown in this photo that's on the screen, or the property line alleged in the survey by Sewell, apparently. Either way, it's the building, the foundation, the wall, let alone the eave, which code describes as the architectural projection, must be within the set or outside the setback. So that remedy of, quote, simply slicing off the eave still makes it less of an intrusion, but it's still an intrusion in the setback.
Would that though get it within the realm of that 30% administrative?
It
doesn't change anything. 30% still has the same standards.
Right. Yeah, it's, you know, administrative isn't just a whim.
No,
like I said,
I
it
understand
still
that.
has to be.
I understand that.
The variance requirements still have to be met. So, I don't know. It's and the issue about the chimney, I don't know that it's germane because it's the building itself. And unless somebody's willing to create a building wall and foundation 5 feet from the property line and deal with the building that way, it can be done. But So what?
And it's tough too, because I really don't have a problem with anything, but the setback is tough because the application is for 2 feet 8 inches. And if the 1.98 inches is correct, then if we approve the variance, it may still be wrong. Yeah, it may still be out of compliance.
I know from past discussions, not just here, but nationwide, side yard setbacks. Here we've got 5-yard side yard setbacks, so literally 2 buildings could be 10 feet apart. And that's to the east. That is just plain minimal as far as protection and anything to do with that side property. And yes, this area has fire protection. There's fire station up there at the lake and so forth, but that's part of the safety measures that the code envisions by putting in that 5-foot setback. Plain and simple.
Commissioner Glasso, I heard earlier about the 16 inches, and that's kind of horseshoes and hand grenades. 16 inches is 16 inches. And when you, in fact, violate on that, we are dealing with conclusion number 3, where you are violating the safety of the other vicinity or subject parcels. I mean, it's clear right there. 16 inches, it could be 5 inches, but you still are encroaching on the neighbor's safety. And that's why the ordinance is written, and that's why we can't just pass variances because somebody had an oopsie with a contractor. We have to look at conclusion number 3. And I think Ms. Moline made a very good point in regards to that.
Okay, let me pursue this a little bit further with staff. So the variance was for all the requests together. That's the file. Not sure or therefore comfortable with separating them out. Would that be a course, or I think we could probably put something together to that effect, but I don't know. Anybody got any further thoughts on that? Because the file, the application was for the variance covering the 3 items. If we say yes on 1 and no to 2, or 2 to whatever combination.
We've done it with amendments, but we haven't done it.
Yeah, right, because then you can separate them out. Right? But here, I'm not so sure about a variance, whether it's all or nothing, or maybe that's piecemeal. I don't know that the code addresses it at all.
There's not. I can't support it. I think it needs to go to the commissioner's person. Because there's going to be, if we approve it, there's going to be litigation against the county. And I think the county commissioners need to make that decision.
Yeah.
So that's
okay.
my opinion.
Other thoughts?
After working up there all the years that I have on that stately laws for years, the state was very careful about any improvements, and they made sure they met setbacks, drainage, things like that. As we saw a while back, we had another one of these, and sometimes folks don't maybe pay as close attention as what they should. And now that the state isn't there to monitor everything, but they have such good maps typically in place. It just baffles me. The topography is similar to so many of the lots, and other people have gone to great measure to put in walkways that switch back or whatever to meet requirements.
Mm-hmm.
This situation, that lot that was there, it appears to me that the the development is what's causing the problem, not the lot. That lot was in existence, here it is. So if you start developing, you need to follow rules and regulations like all your neighbors have done.
Okay.
Thank you, Commissioner Reeve, because that deals with conclusion number 1. And conclusion number 2, hearing that it, well, we're over in Washington. We can't help it. We're not near North Idaho. Well, you know what? You bought the property here. You're developing it. You need to stay on top of it. I know you have to drive 3 hours, but you need to be on top of it. And that is a responsibility of the landowner. So that addresses conclusion number 3. So I think all the way down the line, we have a responsibility.
Okay. Any other thoughts, or are we ready for a motion?
Are you ready?
Susan, did you hear what she said?
I didn't hear that.
In making a motion, we will have to read the conclusions of law into the motion.
Right.
Okay. Just to make that clear.
Are you ready?
If you're ready to
Mr.
make
Glassell,
Go ahead.
are you ready?
Yes.
Okay. Mr. Glasso, I motion to deny. I move to deny this project file V0013-20, a 2-foot 8-inch side yard setback where 5 feet is required, a walkway with variance of 6-foot 2-inch retaining wall height variance where 36 inches is a maximum, and an impervious surface variance based upon the following conclusions. Conclusion 1. Conditions apply to the property that do apply generally to other properties in the same vicinity or vicinity, same zone or vicinity, which conditions are a result of lot size, shape, topography, or other circumstances over which the applicant has no control. Special conditions, circumstances do result in the actions of the applicant. Conclusion number 3, the granting of the variance is in conflict with the public interest in that it will not be detrimental to public health, safety, or welfare, or materially injurious to properties or improvements in the vicinity or the subject parcel or lot. The decision is based upon the evidence submitted up to the time the staff report was prepared and testimony received at this hearing. I further move to adopt the following findings of fact and conclusion of law as amended. This action does not result in a taking of private property. The action that could be taken, if any, to obtain the variance is to file a new application with the Planning Department and meet the standards required by Bonner County Revised Code, or appeal the Planning and Zoning Commission's decision to the County Commissioners.
We have a motion on the floor to deny variance B0013-20. Is there a second?
Commissioner Reeve, I second that.
Okay, motion and a second. Any further discussion on the motion? Hearing none, call for the vote. All in favor of the motion, say aye.
Aye.
Any opposed?
Aye.
Say nay. Motion carries. So, all right, that's our first file tonight.
Excuse, sorry.
And,
Yeah.
so, same for those remaining, the same rules of engagement in the room apply as the last case, first case. And the, come on, shoot, I got rid of it. Oh, that's right. Yeah, you can go back to.
Necklace files.
Yeah.
Okay.
Where's the agenda?
Stevens is next.
Yeah, it's Stevens, but I've lost my agenda now. I can't
Oh,
read
all
my,
right, I'll get here.
get the agenda.
Here, I got it here.
Okay.
Come back.
Come
Here,
back, come back.
here you go.
All right. So,
Oh, here.
okay, we got it 16 different ways. Okay. So it's now 6:56 and we're going into file V0016-20, waterfront setback for Brett Stevens. And any conflicts of interest, there is up on the board. Conflicts of interest on this one? Hearing none, okay. And anyone in the audience needing assistance to participate, let us know. So as the procedure states, first thing is the staff report. Ask for that, please.
Good evening, Commissioners. This is Aaron's request for Stevens, 16-20 Frank Pier Yard shoreline setback. So this is the parcel we're talking about. It's this parcel right here. It's at the end of Kilroy Bay. Applicant is requesting a variance from setbacks to allow for flexibility in development, including a 6-foot waterfront setback with 40 feet required. This is a picture of the property, including his development, what he would call his development envelope. We asked him to do it this way because we spent great length trying to determine where he would locate on this property. The challenge is that it's zoned Ag Forest 20 and so surrounded by that. And so properties abutting those types of zones have a greater setback. And so that's why we're here for the variance for the side yard setbacks, but then for the waterfront as well. He doesn't have big plans to develop a lot of stuff there. He just has plans to, storage for a beginner and then maybe a small cabin to live there. Parcel is only 0.58 acres. It's unplatted at this time. It is next to platted lots, but this one is unplatted. It's accessed off of Lake Pend Oreille. It's mostly sloping away from the lake. Floodplain's unstudied, floodplain deep. The zone type, the soil type is Pearson Creek, Marble Creek. So it is not prime farmland, but it is well drained. Power is in the area by Northern Lights. So again, it is AF20, surrounded by AF20. There is lots of big vacant lots around it. I'll show it to you in a sec. So the property is longer than it is wide, offering less opportunity than the adjoining properties to accommodate a 40-foot setback against the steep slope. So at its shortest point, the width, the depth of the lot is only 50 feet. It varies up to 100 feet in depth. I just used the mapping system to figure that out. So this is the property with the slope layer turned on. You see some of again, the challenge with the sloping layer is we don't know exactly where it lays down on this map. We can guess. We do know that the map is off, and so it is likely that there are some benches along the shoreline here where he's able to put structures that are not on that 30-foot slope. But that's what's pushing him down towards the water is this steep slope, this 30% slope. And you see how it falls all along the property lines of these others. So, of course, the applicant's not responsible for that slope or the shape of the lot. I didn't go back and research to identify and tell you how the lot or when the lot was created. But basically, this is what he's asking for, is a development envelope to allow him to build 6 feet closer to the property. So no comments except for Fish and Game. which are concerned over nutrient loading and shoreline setbacks, same comment that was in the previous file. And that's addressed through stormwater and erosion control plans. Basically, Fish and Game is asking that they slow the flow of water when they create impervious surface. They slow that flow of water into the lake so it has a chance to cool and sanitize itself, so it doesn't create new nutrients that are harmful to the lake and then also do warm up the water. So that's some of the concern with that. I'm probably talking way above my pay grade. And so so that's the challenge with this code, is to balance the right to build a home versus the setbacks and other standards of Title 12. So due to the slope and the depth of the parcel, staff determined that the request was consistent with the code. If you mitigate the concerns with the stormwater, it makes sense to allow a variance to build 6 feet from that shoreline. The PhD did comment and say that the septic permit had expired without being built. So he doesn't have a way to address that on the property. Again, that's not unusual with the way the lot is out there all by itself. It's he's definitely got some challenges to building and challenges to putting things there, but he still does have the right to use it. So his biggest request was, again, to be able to start with a structure that would allow him storage and then slowly move into those other phases of a cabin. And there's lots of ways to address PhD's requirements. We have a gentleman that built on a property similar to this to put in not incinerator, but the composting toilets. So there are other solutions to that. So the lot is not unbuildable, but it's definitely limited where it can be built. So that's the request. To say the least. Big challenge. He's online? Okay. Be good to hear from him.
I am here. Thank you very much for your time and consideration of my variance requests and for the presentation of what I'm seeking. That was very clearly spoken. Essentially, I've owned the property. It says in the variance since 2008. I've actually owned the property since 1998. And like my neighbors, I just am seeking the ability to use the property without being in a violation of any code or anything like that. And the only places on the property that are usable are down by the water, just like my neighbors have. And really, I'm just seeking a spot to put storage. I've camped on the property for since I've owned it. And that's my immediate plan. And the variance, as stated in the recommendations, they've stated to do 50% of the linear footage of the property, and I have no problem with that. When we did the variance and talking it over, I just created that, it's the shoreline is where those benches are, but I could certainly go with a less square footage. It's recommended 50%, and I have no problem with that, but this allows me to have a potential to use the property and enjoy the property in the future. And so I'm respectfully requesting that you grant the variance. Thank you.
Okay, any questions for Mr. Stevens?
Mr. Stevens, did you ever live in California?
Yes, I did.
Did you live in Laguna Beach?
No,
okay.
No.
Okay, I don't have a conflict then, thank you.
Yeah. All right, very good, thank you. Okay, any other questions for Mr. Stevens?
No, that was it. I just had to clarify.
Okay, thank you.
I played
Yes.
football with Brett Stevens.
Ah, yeah. All right. Okay, thank you. So we'll move on to, anybody here in the room have any testimony to give on this file? Doesn't look like it. So I don't think that means that you need to respond to anything because there's nothing to be said.
Well, we do have a.
Oh, there's other people called in. Oh, okay.
I mean, I don't know if they're here for that file or not, but.
All right, if anyone's listening out there, I know there's people who are on for the code change workshop. But if anyone is interested in this file, B0016-20, now is the time to speak up. Either just shout out, put something in the chat box, or raise your hand.
You have one in the chat.
No, it's on.
Okay. All right, doesn't look like we have anyone interested in this file from the, I don't know what we even call that, the audience. Okay, therefore, thank you, Mr. Stevens, for your testimony. And we'll close the public testimony portion and open for deliberation. So I've got one question, and this is more of a background question, or maybe it's a statement. Kilroy, good old Kilroy, it's been there forever. Why is it still AF20? Why isn't it recreation?
I'm not even gonna answer that.
Yeah, but it's kind of a rhetorical question.
Thank you.
So that we'll get there when we look at comp plan issues, because and I guess the underlying question of that is how much of this would be not necessary if it was recreation? A lot of it may not be necessary.
Except for the shoreline setback.
Yeah, it still requires a shoreline setback. And these, but here we've got, I can't even count the number on the aerial, other lots in exactly the same situation. So, anyway, okay. Put that aside because it's not part of it. So what thoughts are going through everybody's head? It's a very constrained situation, obviously.
Yeah, it's pretty steep. You know,
I've been there.
6, 8, 10-foot waves.
Yeah. That was one of my only concerns. This is obviously, and I'm somewhat familiar with that shoreline, and it does rise up pretty quick off of the summer pool. But I didn't see anything on the, anywhere that indicates absolute elevation.
Right.
Do we know? And as was stated, the slope map, it's there and it shows there's slope, but it doesn't fit the ground. Neither does the graphic showing the lot, et cetera. So, you know, we're hampered by computer graphics and GIS and not actual survey or. That bench is there, and so many of the benches, and this is anecdotal, so many of the benches were created by previous storms around the lake and deposited material, and then hasn't happened in 100 years and all that kind of stuff. But that's, again, that's totally anecdotal.
Mr. Chairman, Commissioner Lynn Scott, I move to approve this project file V0016-20 for variation in the setbacks of this property with a specific request for a 6-foot waterfront setback where 40 feet is required, finding that it is in accord with the Bonner County Revised Code as enumerated in the following conclusive law. Based upon the evidence submitted up to the time the staff report was prepared and testimony received at this hearing, I further move to adopt the following findings of facts and conclusions of law as written. The actions that could be taken to attempt various to complete the conditions of approval as adopted this action does not result in taking of private property.
We have a motion on the floor to approve file V0016-20. Is there a second?
Commissioner Bailey, second Commissioner Linscott's motion.
Motion to approve with a second. Any further discussion on the motion? Hearing none, all in favor of the motion say aye.
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 Any opposed? Say nay. Motion carries. Okay.
Did you vote?
I'd say aye.
Oh. Okay.
Spaced out.
All right. So that's the second file.
Chairman, can I take a 2-minute recess?
Yes. 2-minute recess. So come back at 7:13.
With that,
Gotta get his. All right.
understand your whole deck.
Yep.
Yeah. Yes. And then me again. And then, yeah, we should vote that.
You said we go to the very, yeah.
Do you make copies of those?
Yeah. Oh, great. That's not cost.
Yeah, I didn't. I can. Janine? Will you text Haley and ask her to send some copies? Any copies? Some copies for commissioners?
You know, there's two for his phone. He's the fifth one. I don't know. Yeah, it's all. Moving along steadily here.
Wayne, yeah. We ought to dive into a few more of that stuff.
Oh, sorry. How do I do that? Just over here? Okay.
She's on her way out.
She just went out to check on her dog. She needs to find out. You know, her last name.
So we're gonna do MBIT?
Yep. Well, that's what I was wondering.
Yeah.
I didn't look for his name on the list. Jeannie is the.
Yeah.
Oh, that's Josh. Almost go like crap.
Yeah. The applicant online, on the phone?
Hopefully, I don't know the answer. No, Ivan's not in the.
No, not in the room, so. And I don't know.
I don't know if he's here or not.
Nope. Okay, whoops, we're missing one.
Are we doing the 17-20?
Yes.
Okay, good.
Lynch is on the line.
Commissioners, can you hear me now?
We can hear you.
Fantastic. But
We gotta wait a minute because we've got one commissioner out of the room.
Yes.
perfect.
Yes, thank you.
Actually, we have two out of the room, one far out of the room, one just down the hall, so.
Thank you for the clarification.
Yeah. You're welcome. Yeah, Suzanne, it looks like it might be coming up with a pretty sunset in a few minutes.
Well, I'm staring at deer right now, but just saying.
Okay. Okay, yeah, there's enough clouds in the sky, and apparently a little smoke too, so might get a pretty sunset. Sure will go. Sounds like she ran into somebody. Might have been. Yeah, she can push her. Okay, so it is now 17 minutes past 7, and we're resuming the hearing, and we're taking up file V0017-20 variance request by Ivan Envik. So, any conflicts of interest on this one? Things to divulge?
Commissioner Brash, I've done quite a bit of business with Ivan in the past, and it will not affect my ability to make a decision.
Thank you. All right. So, staff report is the first item on the agenda for this case, as all cases. So, staff report, please.
Thanks, commissioners. As stated, this is file V0017-20. It's a request for variance.
Yeah. You might as well tell us who you are.
Sorry, commissioners, Josh Pilch, staff planner, Bonner County.
Thank you.
This site location is off of Gun Club Road and in Sago. You can see there in the picture that the highlighted in yellow is the 1 1/4 acre that this site is located on. Project summary: the applicant is requesting a variance for a 2-foot property line setback where 5 foot is required, and an 18-foot setback where 25 foot is required. To bring an existing sign on the property into compliance. According to the applicant, the current location of the sign is the best place for the traffic to see the sign from the road. Again, that's Gun Club Road. And it also indicates the location of the driveway entrance. Moving the sign would cause visibility issues due to trees and driveway placement. The driveway was originally built to maximize the use of the narrow lot, and the sign helps indicate access to the property. The purpose of the variance is to resolve the building violation as the applicant did not know a permit was required for a sign at the time of placement. This is looking west from Gun Club Road towards the driveway to give it kind of an indication of what the front of the property looks like. You can see the sign in the background there. It's the orange letters. And there is between the utility poles and the trees, there is a few things blocking the visibility there. Background, the site, it's at 218 Gun Club Road. It is platted. It's 1.25 acres. The zoning is commercial and the land use is transition. Again, the access to the property is off of Gun Club Road, which is a paved county maintained road. The site does not contain mapped slopes. It does not contain mapped wetlands, and does not contain a river, stream, or frontage on a lake. The services are Sago Valley Water and Sewer. The sewage is a septic system. Selkirk Fire District is the fire district it's in. Power served by Avista Power, and it's in School District 84. Here's another picture of the sign. You notice the gravel driveway there behind the tree. We sent this out for agency review back in July. Panhandle Health District, no response. Selkirk Fire District, no response. Northern Lights, no response. School District, no response. Bonner County School Transportation, no response. Sagal Sewer Water District, no response. The one agency that did comment was Bonner County Road Department, which maintains that paved road out front, Gun Club. And Road and Bridge stated, Road and Bridge has no obligations to the, no objections to the proposed 18-foot setback for a sign along Gun Club Road. The sign is sufficiently far back as to not affect our maintenance operations. So that was the comment from Road and Bridge, that they didn't have an issue with the current location of the sign. And we did not receive any public comments. So we went through and looked at the standards, standards review. Do conditions apply to the property do not generally apply to other properties? The applicant's driveway is close to the property line. Jointing property is owned by me also. Staff, I was able to go out on site and meet with the property owner on August 5th. Met with the applicant on the property to examine the conditions associated with the sign. A site visit revealed that trees and vegetation and to cause an obstruction to the visibility of the sign, which is not the case for neighboring lots. The lot to the west has also been developed and still remains vegetated, and the parcels to the east have been developed and do not have obstructions caused by trees or vegetation from the neighboring lots. So continuation of the standards review, special conditions and circumstances do not result from the actions of the applicant. The driveway is too close to the property line. The driveway is too close to the property line and the sign needs to be located at the access of the property. The purpose of the variance is to resolve a building violation, as I did not know a permit was required for the sign. Staff, property owner did not plat the original lot. Due to the narrow lot design, landowner placed the driveway on the western lot line in order to maximize lot space and design. As you can see, there's other pictures, an additional picture of the sign from the road. Final standard review. The granting of the variance is not in conflict with public interest in that it will not be detrimental to the public health, safety, or welfare, or material injuries to properties or improvements in the vicinity of the subject parcel or lot. Applicant, the sign it is not in the way of the site of traffic. Staff, no adverse comments were received on behalf of this project. Additionally, Road and Bridge has no objections to the sign as placed. So staff analysis, staff concluded this project is consistent with Bonner County Revised Code based upon the following: the establishment of the plat, the year the applicant obtained the property, and the establishment of ordinances in Bonner County have been verified and illustrated. The applicant had no hand in the current lot size. The condition of approval as proposed or amended will ensure that granting this variance will not be detrimental to the public health, safety, or welfare, or materially injurious to properties or improvements in the vicinity of the subject parcel or lot. Bonner County Road and Bridge submitted a comment stating there are no negative effects of encroaching the front yard setback. Additionally, the purpose of the ordinance can be satisfied and will not be detrimental to the surrounding areas. And I'd take any questions at this time if you had some.
Questions for staff? Questions for staff. Josh, I have one question, Commissioner Bailey.
Yes.
Is that sign meet the 4x8 criteria?
It does.
Okay.
Okay. And Josh, do you know, you looked at the sign, is the sign, it looks, I can't tell if that's concrete or rock.
It's concrete.
Concrete, so formed up concrete with formed in letters and so forth. Is it sitting on are those posts concrete as well, or?
It is. There's a footing poured and then concrete poured for the legs, and then a slab poured and then set on top of the legs. It's pretty stout.
Yeah. Yeah. Okay, just want some clarification whether the thing was sitting on posts or whatever. Okay. All right. Thank you for the staff report. Now, is the applicant, do we have the applicant on the phone, or?
Was there?
That looks like we do. I don't see his name. No? Okay, so we don't.
Was there started?
Well, so we don't have the applicant, but he submitted the file. So does anyone, without an applicant's presentation, we've got staff presentation, anyone here care to comment on this application for NVIX? Oh, okay.
It's a nice looking sign.
Yeah, all right, so we're in deliberation. Close the public testimony, and we're in deliberation. Great looking sign. I have seen it.
So these guys do quality work, they just got it wrong.
And it appears on this photo we're looking at, on the right-hand side, right up against the frame of the photo, is the electric box. That's the, I believe that's the, yeah,
this
transformer comes off the power, the pole right there, and goes to that transformer. So the driveway is snugged up sort of against the west side of the lot. Yeah, it's not that it can't be moved and all that stuff, but that excavator in the back of the picture moves stuff, but okay. Any other comments, thoughts?
The only comment I have is I believe his map is flipped. Because here on his application map, he's shown the driveway on the west side lot. I believe the driveway is actually on the east side.
Well, that's the cell phone.
Oh, so, okay. Spinning it around, selfie. Yeah. I don't know if that really.
Well,
Yeah, I'm wrong. Maybe that driveway is on that side.
Well, the driveway is on the west side of the lot.
Okay.
Right, snug up against it.
Okay.
And
we're good then.
And yet there's 155 feet of lot frontage there on Gun Club. I don't know.
I'm ready to make a motion.
All right. Make a motion.
Mr. Chairman, Commissioner Linscott, move to adopt this project file B00017-20, a 2-foot property line setback where 5 feet is required, and an 18-foot street setback where 25 feet is required to bring in an existing sign on the property into compliance, find that it is in accord with the Bonner County Revised Code as enumerated in the following conclusions of law and based upon the evidence submitted up to the time the staff report was prepared and testimony received at this hearing. I further move to adopt the following findings of facts and conclusions of law as written. The action that could be taken to obtain the variances to complete the conditions of approval as adopted. This action does not result in taking private property.
Okay, for the record, would you just restate your initial going into this? I move to
approve this project file B00017-20.
To clarify, you said adopt, but we need to approve. Okay. All right, that's clarified. Thank you. So we have a motion on the floor to approve file V0017-20. Is there a second?
Yes, go ahead, Sue. Go ahead.
Commissioner Reed, by second.
So we have a motion to approve and a second, file V0017-20. Any further discussion? All in favor of the motion, say aye.
Aye.
Any opposed, say nay. Oh, we didn't hear from Suzanne.
She's still there.
Look at it, dear. Suzanne, yay or nay on the motion?
I apologize. I was still on mute. Yes. Yay.
Yay. Okay, so we have a unanimous decision on this one to approve variance 17-20. Okay, so moving on, we have the next file is it's AM 0010-20 and ZC 0007-20 comp plan map amendment and zone change for Benjamin Dorn Living Trust.
Thanks, Commissioners.
Any experts on any conflicts? No conflicts. So staff report, please.
So this is a request for a comp plan amendment from agricultural forest 1020 to rural residential 510, and a zone change from AF10 to R5 in section 23, township 54 north, range 4 west, Boise Meridian. This is out off of Kelso Lake Road. We recently did some zone changes down below earlier. This is the parcel, approximately 113 acres. I'll show you a little bit more about the topography in a minute. There are some wetlands present, and I'll show you that. And there is slope running through the property. The soil types, however, is Bonner gravelly, Ashley silt loam, and 0 to 4, and then 30 to 65% slopes, well drained. Sewer systems are provided, on-site septic systems watered by on-site wells. Northern Lights provides electricity to the area. This is the topo map with all of the natural resources turned on. So you see the floodplain follow this property. It touches the edge along here. The wetlands does the same thing. The wetlands just touches right down through this piece of property here. The slope, you see the slope, how it runs through the property. It goes along the property line here, follows along the railroad. This is the railroad right through here. The slope follows along that railroad and then splits the property. So the request is to change this parcel from AF10 to rural residential. So the ag forest plan designates areas where steeper slopes prevail. Transportation is provided by private roads. Urban services not available. Residential development challenges are present due to slope, poor soil conditions, hazard areas, and lack of police. That is not the case in this request. There is definitely services, good soil conditions. There is some slope, but they don't prevent huge challenges. Resources and exposures to loss of property or lives. So this is the comprehensive plan, the land use map. You'll see that rural residential is indicated on 3 sides of this property, and that ag forest 20 is the remainder. I understand that probably a lot of the reason for that was because of its location, and that the railroad does divide this in one way. Nevertheless, the zone change does allow, the zone definitions do allow for R5 on this property based on the topography. So when we look at the zone map, AF10, this is all zoned AF10, but again, it's zoned R10 on 3 sides, which is interesting because these lots here are of course less than an acre, in some cases 0.2 acres. These lots up here are 5 acres. These lots here are all 5-acre lots. And so how it's zoned R10, I'm not sure how that happens. Nevertheless, those subdivisions are in place. Public comments, none. Clark Fork, Priest River Independent Highway District, Monterey Hospital District, no comments, no public comments, no letters from folks.
Yes, there should have been a letter. We received one.
I did not see one in the file.
I
will look in.
in. Okay, I asked in planning and they said you received it.
Okay, I will.
It's in here, we have it.
You have it?
Okay. Mr. and Mrs. Jerry Stark, is that the one?
Yes.
Okay. Yeah, we have it.
Okay, good, thank you. I'll check the date on that. The property is designated Ag Forest and Zone Ag Forest 10. The designation was designed for areas that are difficult for development due to steep slopes. Slope is present as shown. There is limited wetland. The property is accessed by Kelso Lake Road, county maintained road. The property contains well-drained soils intended with the rural residential designation. Section lies in the Spirit Lake Fire District and Bonner County School District 83. It's bordered by 2 5-acre subdivisions on one side, a sub-area subdivision on another. There's also large acre lots neighboring this property. One contains a lake and extensive wetlands. The same person owns both parcels. It is, so then again, for the zone change staff analysis, the property is bordered by 2 5-acre subdivisions on one side, the sub-area, sub-acre, should say, subdivision on another. There are also 2 large acre lots neighboring the property. So the person that owns this also does own this parcel here that takes the way. So, but this is the only one that's on the request. Is this 113 acres? Again, showing the subdivisions, the neighboring 5-acre subdivisions that are close to this. And again, just down Clackstone Road was recently rezoned. So. All right. Good. Okay, not sharing, we could find that one.
Yeah, it's in. Why did you send a letter to Clark?
So amendments they have to go to all the taxing districts. So that's why all the taxing districts.
Yeah.
So there's some that are really good at just responding, right?
Well, yeah. Yeah, that's, seems like a mystery, but there's a reason. Okay, so any questions for staff at this point? All right, so we're at the point where the applicant or the applicant's representative comes forward, and do we have the applicant? We don't have the applicant. And I didn't see, I didn't see on the phone list. There we go.
Hello.
Hello. So go ahead, please.
Hi, my name is Melissa Dorn. I'm representing the Living Trust. Thank you for that overview and for considering this application of changing the zoning and the comprehensive plan.
Okay. Any further information you'd like to give us?
I think you covered it fairly well. We're just looking to be able to subdivide the property to sell off some land for residences, especially towards that area where there's the sub-acre development to kind of bolster our property values. We had a death in the family a couple of years ago when it transferred into the trust. And so it's going to be a better use for us to be able to sell some of that acreage.
Okay. Any question for Ms. Dorn? Okay, hearing none, thank you. So at this time, anyone who wishes to say anything in this file, please come forward to the.
Yeah, so, and just to clarify that the letter did come in after the staff report was prepared. So,
okay,
that's why I was missed.
We have the letter in
It's
our
in the
file.
file. You do.
Yep. So, thank you. So, I take it the Starks, you may want to testify. We have your letter, your detailed letter, but go ahead.
Actually, the same, most of the same points pertain as did the last 4 or 5 times we did this, but with a few changes.
Can you state your name, please?
Oh, yes, Judy Stark. Do you need the address? 6799 Clydestone Road. And we are just to the south of Thorn's Place. On assuming the stated goals of protecting the character of the area and the quality of life and the wildlife and the environment and everything are still in force, the purposes are to protect property rights, ensure the important environmental features are protected, which in this case is rural and natural, being next to several large properties that have wildlife and state and federal land. The impact is more considerable than just 300 feet from the property line, in this case particularly. You were mentioning that the 2 5-acre developments up on the west side of the railroad track, you didn't know how that came about. We don't know how it came about that they went from requiring 10 acres to being reduced to 5, which was not wanted by people in the area at that time. It would seem that we have enough development of 5-acre places that the impact is already considerable on the wildlife, on water is another thing, that putting more wells and septic above, yes, it's well drained. However, the springs that feed what we call the pond, but it's actually Upper Hoodoo Lake. But the springs that feed it are all coming down through the basalt, the cracked basalt and what have you. And the lake, the pond is not a freestanding one. It's part of a system that comes from up the Hoodoo Valley, goes down through both the creek and the drainage ditch to Lower Hoodoo Lake, and then on through the Hoodoo Valley to the river, the Monterey River. So what affects that is going to affect a wider area than what just is there. And we have been there since 1981, and we have seen the development, we've seen the results of the development that not necessarily good. It's at 20 acres, we bought in when it was supposed to be 20 acres, and that was fine. When you have protection for the wildlife and the wildlands around there, it makes sense if you have 20-acre parcels next to those areas, and then you go down to 10 acres, and then you go down to 5. But it seems that for some reason, in the past, it seemed the commissioners and the planning thought that 5 acres was a better way to go. And it's not, the impact on the area is not good. The quality of life has gone down. The rural character kind of is not necessarily protected as it would be. We have gone down from our water for irrigation, to which we have permits, has gone down from being able to water for 8 to 12 hours at a time, our pastures, especially when we were raising sheep. Now we're down to an hour and a half to 2 hours. And so there's an awful impact on the water supply, whether it's showing at the surface or not. And so we're a little concerned that disturbing with the building is going to cause contamination of the water supply. The people there bought there because they like the rural atmosphere. We bought knowing it was 20-acre minimums. We didn't know until just now that we are now R10, which we didn't know about, and perhaps we'll have to petition to be R20 when it becomes available. But the 5-acre places are putting a great strain on the roads, put a great strain on just all of the ambiance, including poaching and theft. The location is, just because there's 5-acre places around, doesn't really mean that there should be more 5-acre places around. There could be more 20-acre places around, or the Clagstone development for Clagstone City's been there for 100 years or so. That was a long time ago that those were made into the very small area. And the encroachment, which is supposed to be controlled by planning, has gotten to be more and more dense encroachment. And the idea of having the density stay near the cities is a much better one. This way, we're running out of rural land, we're running out of wild lands. So adding more density to this area is going to change things all up and down the valley. The next thing we know is the next place up the way is going to be, because there's 5-acre parcels here, we need to make more 5-acre parcels. And to be honest, if we want our quarter section to be divided into 5-acre parcels, we'll come and request it because it's apparently easy to do. But what we want, and what most of the people that we know that live around there want, is larger acreage so the animals can pass back and forth without eating your dogs. And the people aren't going to be impacting the wildlife as greatly. This land has been used for forests. We grow trees and we harvest them. It's been used for agriculture. And we like the rural atmosphere. That's why we moved there. We've been there since '81. There was no houses between 54 and us when we moved there. There were people in our spot, but that's why we had small acreages. But we were asked that this will be allowed to stay as it is, with 20-acre parcels, and let the character of the rural character stay the way the residents want. We've had outsiders come in, buy the property, the two 5-acre developments. Outsiders come in who don't own the property. They buy the property for the purpose of development to change the character of the area. It would be better done closer to town, not continually changing what the people there have paid and really enjoyed. So basically that's, as I say, the letter is basically the same points as before. We still want to keep our rural atmosphere. It's important to us. Any questions?
Questions, Ms. Stark?
Thank you.
Thank you. Anyone else care to say anything?
Yes, please.
Name and address for the record, please.
My name is Ann Aizawa, and I'm at 2921 East Bruner Road in Athol. But I am part with my sisters, we own next to this parcel where some of those larger parcels that they were talking about. I don't know if I can make this work. Like over in this area, this is all ours. So this is going to impact everybody. Growing up there, we've owned that property there, and we used to own the property that's being discussed. And we used to hay some of that and we grew trees on it. And growing up there since '63, we've seen a lot of changes. And increasing the density, again, is not going to be healthy for the environment. You can use as an example Dalton Gardens, beautiful area, but it's 5-acre parcels. There's deer going through there all the time. I hear all kinds of people, because I work in Coeur d'Alene, complaining about the deer coming through. And it's a big impact on the wildlife. This is going to be an impact on the wildlife. This is on a north-south flyway. We've seen hundreds of swans come through there in the spring, hundreds of geese come through there in the spring and fall. As they're heading south or they're heading north. We have all kinds of different waterfowl, teal, I mean, I can't really name them all because there's too many. Elk, moose. Over the years, we've seen an increase in moose. When we were growing up in the first 40 years that we lived there, probably see a moose every once in a while. In the last 10 years, because of moose being listed as they are and only one tag, I've seen more moose in the last 10 years than I did in all the 40 years prior to living there, which is this is going to really impact. I'm wondering, has there been an environmental impact statement done, a study done, so that we could see what this is going to do to the environment, like the waterway, like the flyways, the migration paths of the different animals. I'm just wondering if enough study has been done to see what the density increase is going to do to the environment. I'm just hoping that, you know, we can see the forest for the trees and maybe not be really quick to pull the trigger on really short or small areas of property. We need to make sure that there's enough fire protection for those homes. I know from growing up there, and I know it's changed a lot now, we fought our own fires out there. And it's a long way from a fire station. It's a long way from a fire engine. We have a neighbor at the Starks. He has a water tank that's been used on our property before. And I mean, that's about the closest fire that there is. To get out of there is probably going to be by helicopter if you have an issue. It's a beautiful area. It was a beautiful area to grow up. I understand people wanting to make money. I understand people wanting to be in that area. But why can we not be in that area in 20-acre lots instead? If you want to be out there and enjoy the environment, then be out there in 20-acre lots. Why are we making them be small when you could have small in town? I'm just, I'm hopeful that maybe we could get an extension and we could look into studies before this gets zoned or rezoned. And we just look at seeing maybe if we could get an extension to look at some of the impact on the environment, on the infrastructure, on the density. What's this going to do? Because, you know, I know they're not making any more land, but we're making an awful lot more people. So we have to be careful with what we have. So I thank you for your time.
Mr. Chairman, I have one quick question for staff.
Okay.
This is currently zone Ag 10, correct? It is. It's not 20-acre tract, it's zone Ag 10.
Yeah, it's Ag 10.
And just maybe for a little bit of clarification as well, I have the 1992 zone map, and everything down in 54 North, 4 West, entire section was zoned rural. And at that time, rural was 5-acre tracts, so it has never been zoned for 20s down there. Never has.
In the 70s it wasn't?
We didn't even have zoning until 81.
That's,
81.
Yeah. But and there's, it doesn't
We
really.
may have been misinformed, but everyone out there thought it was 20s and they wouldn't allow it to be sold.
Okay, so it is the land use designation that's AF 10, 20.
Yeah, yeah. And granted, I mean, this area, Flagstone, there's a lot of history back in the turn of the 20th century. Things happened then, et cetera, et cetera. And then, like I said, 81 is when the zoning code came in. So we got 70, 80 years of history before the zoning code came in this area, which is the result of what you see on the map. Okay. Anyone else care to say anything? Yeah, go ahead, come on up.
My name is Julie O'Brien, 5022 Kelso Lake Road. So we live there. We live right on Kelso Lake Road. I'm sorry if I cry because we have, like my sister, we have been there since 63. Because of Hoodoo Lake that Judy mentioned, we've got bald eagles, we've got red-tailed hawks. We had this spring at least 200 pair of Canadian geese that nested. That's probably going to be non-existent. We have moose, elk, and deer that come down from the woods across the road down to the ditch, we call it, twice a day at least. With that much traffic on that road, I can't see that being a benefit. We have turkeys, blue heron. We had I counted at least 100 swan this year in that Hoodoo Lake. I just can't understand how that can be changed or not at least contemplated. That lake is full of bass. And this is going to just dramatically impact their habitat. We also have the Audubon Society that's been coming out for years, and they have research going on. They have bird nests along all our fence posts because they have been doing research for the different birds. When you said that's well drained, I question that because we did own that property years ago. We used to hay a portion of that property. You can't walk out there anymore. It's not well drained. It is, the water goes down significantly, but it's been so affected by the non-drainage. Over the years, we've lost probably at least 200 acres of prime agricultural land due to the wetland designation. That's been a huge impact on our family and our lives. So I wonder what this development, why it's being allowed with the wetland designation when we can't maintain hayfields. Again, like my sister said, has there been an environmental impact done for the animals, for the agriculture, for the roads? Sometimes they're barely passable because the ruts are so bad. You have to drive 2 miles an hour or you're gonna, your truck's gonna fall apart. I can't imagine how this much more traffic is going to affect these roads. People fly through there at 60, 70 miles an hour. It's a 35-mile-an-hour road. You mentioned that there's police there. We're on the southern end of the county. We don't see many police, and we don't have, the police station is up here. There's not a lot of police protection down there. And then I just am wanting to ask if we can't have a denial tonight, if we could just do an extension to do some more research on this and really see how it's going to impact the area. And it's a rural area, it's agricultural, and that's what it really should say. And I question the 20-acre thing and the 5-acre thing. We've been told that we cannot sell anything less than 20 acres. So I don't understand how there's some miscommunication there, because the 5 and 10 acres has never been even thought about because it's always been 20 acres. So I thank you for your time.
Thank you. Anyone else?
Okay. I'll just pull it down. I'm Darcy Birdsell, and my address is 5399 Kelso Lake Road. My husband and I bought 60 acres, and we are, I don't know if I can show you on here. We are right over in these, we have these 3 lots, I believe, is what we have. So we are on 60 acres. We bought out there because we understood that it was a 20-acre minimum, and that was part of the reason we chose to buy there. We didn't want to be in a 5-acre subdivision. We didn't want 5-acre subdivisions around us. So we're already cranky that they want to do 5s. But on top of that, if it goes 5s, it's going to have a dramatic effect on the wetlands.
and they are protected, federally protected wetland. So things have to be done a certain way or everybody's in a lot of legal trouble. And I do not see any way that putting 5-acre lots all over this piece of property is going to not affect the wetlands. We are also in a north-south flyway. And so, like they've said, we get the geese, we get ducks, you know, we get all kinds of animals, as well as all of the beaver, the muskrat, the bass, all of the animals that live in the water all the time in that marsh and wetland area. If you put 21 new wells up above there, it's going to dramatically affect the water table. You know, the aquifer is dropping there already. So putting more wells in on that kind of a density is very, very, I had the word, but anyhow, it would be very detrimental to the entire area. We also get there green-winged teal and cinnamon teal, which are very rare in our area. They're not necessarily rare overall, but I believe it was the green-winged teal that is on the watch list. Is that correct, Dan? Yeah. So they actually come in and nest there every spring. They have their babies. They're an extremely private bird. Increasing the human population will drive them out. They will just quit coming. And they are a very beautiful special bird. It's an amazing thing to watch every spring. So on top of all of that, dividing it into 5-acre lots is going to dramatically affect our view. And I'm also very concerned that it will affect the value of our property. I don't know if any of you have driven through Boomtown. We call it Shantytown. It is terrible. And if you do this into 5 acres and it ends up looking like the road there off of Leo Lane, where my friends owned a house on the corner of Simba there, right there on the upper corner, and the 5-acre lots went in next door and there were no CC&Rs and people live there in tents and they are outside, you know, swearing and yelling and doing pot all the time. And you can just see it right from your front window. I don't want to look at that. That's why we bought here. Also, I realized that the area up here has 5 acres and smaller around it, but you have to remember that train track is a huge divider for us. Everything on this side of the train track is large pieces, and that's how we want it to stay. We definitely do not want another Boomtown in our area. So I respectfully request that you would do an extension so that we can do the studies, the environmental studies. But I also would request that you deny this. It's already zoned ag 10 to 20. They're legal with 10 to 20, so do that. But 5s, no. No. So I really hope that you will not approve this request and that you can look into this further and have more information on it. Thank you very much for your time.
Thank you. Okay, anyone else?
My name is Leslie McMaster. I live at 5165 Kelso Lake Road. And mine's rather short. Mr. Dorn and Melissa both stated that the property values have gone down in our area. I purchased my property in 2015 for $69,000. I put a tiny house on it and it was appraised this month at $260,000. I agree with everything that was said. If we could look at the impact and kind of go over what everybody's saying about the property values going down in our area, I think that would be a good idea.
Thank you. Anyone else? Anyone else? Okay, so Ms. Dorn, I hope you've been hearing all of that. And this is your opportunity to respond to any of it, if you care to.
Yes, I do. I do think there's some confusion. We do own 2 pieces of property. We own half of the Hoodoo Lake and the wetlands there, and we are not looking to subdivide the wetlands at all. We're looking to keep that intact. We are also going to be keeping intact any of the area where we have developed our shop and our barn and our house. What we are looking to mostly subdivide and develop at this time is 8 5-acre lots towards the north end, towards that shanty town. our property value has been impacted by that because we have those sub-acre lots right next to our property. We're not able to sell those in 20-acre lots to people who want to live right next to the shanty town. We will be having CCRs in place, and we will be looking to bolster the property value. That's also downstream from any of the waterways. So it won't have a huge impact on the wetlands, and the wetlands will be intact. There's also 8-foot elk fence around all of our property. So there's not a lot of wildlife that runs through that area now to begin with, and it's been that way since 2002. We've lived out there. My family has owned that property since then. And the roads are very good, and I think that's all the responses I had to that. At this time, we're not going to be subdividing the upper acreage as that would on the slope because of the extra road building and everything that would require. So while we're looking to have that for possible future use, at this point, we're only going to be subdividing the lower acreage, the northern acreage towards the Clackstone development.
All right, thank you. No, there's no second, third, fourth, fifth round. Sorry.
See, we can't comment on anything she
Nope.
said.
Nope.
All right.
But she can
Sorry.
comment on ours.
I know.
She's the applicant. She's the applicant, so the applicant gets to respond and rebut if you would. But we can't go 5 rounds. So-
We do have another.
Oh, is there another person?
With their hand up.
Okay, so we have one more. Sorry, we didn't realize that before Ms. Dorn responded. So, so who do we have?
It's Darren Tabor.
Darren Tabor, if you're still on the line.
Yep. Yes. Can you hear me?
Yes, go ahead, please.
All right. Thanks for hearing me, commissioners. Once again, I find myself coming to a meeting in front of you, dealing with requests to change our rural lifestyle to urban lifestyle. As you recall, a few months back, you guys did pass rezoning. I think it was section 25, kitty corner for my property. I live at 8619 Clackstone Road, the entire section from Ag 20 to Rural 5. At that time, we pleaded with the commission to develop an R20 designation, of which you guys ended up disregarding. I believe it was too hard or too much work to do that. Therefore, you guys have put the citizens of Bonner County to continue to try and defend our lifestyle in a rural area versus an urban area at a great disadvantage to defend 20-acre lots when you won't come up with the designation, and therefore these lots or these properties and these sections fall more into what you already have on the books. Therefore, as far as Rule 5s and R5 designations versus 20s, because you guys refused to make one for us. And that's a shame, because the odds of us ever winning a case with you guys until you will heed our request to try and make R20s so that we can maintain a rural lifestyle versus an urban lifestyle is sad. As you've heard, you know, the impacts are great out here in our area. You keep developing more and more sections down to 5s. I've had lots of theft increases over the last year because of that. And now that the section kitty corner from us has gone to R5s, you know, that's possibly, you know, another 100 housings out here whenever they put in the request. Also on your board last time, I don't remember which board member it was because we were done commenting by phone. They said that 5-acre lots were very large lots and allowed for plenty of movement of wildlife and such through that. I was up there today in person. However, unfortunately, the first part of your meeting took so long, I had to depart and come back home. That's why I'm here on Zoom. But I had taken pictures that I wanted to present to the board of Flagstone Road, and many of you have gone down, especially the part in Kootenai County I'm referring to, is as you come off of the highway toward Bonner County on Kootenai County, you can see all those houses in that area are 5-acre lots. Most of them are chain link fenced or fenced. All the timber has been removed from them areas, and I would be hard pressed if any of those people ever see an elk or anything on their property. And that's really the true 5-acre lot designation that happens over time. So I would just wish you would consider denial of the 5-acre subdividing. I would request again that you please consider and put some effort into making a R20 designation so that we have something to go back on that doesn't exist right now, and supporting the citizens of Bonner County with that rural designation that we desperately request. And that's about all I have.
Okay, thank you. I don't know that, Ms. Dorn, that was mainly aimed at the Planning and Zoning Commission. I'm not sure anything there for you to respond to.
She muted or?
It says she's still there, but.
Oh.
Still
Yes,
there?
can you hear me?
Yes.
Can you hear me? Yes, just to say again that our property is completely fenced in an 8-foot elk fence. So there is no deer moving through there right now because they can't get over the 8-foot elk fence. So that being taken down and put into smaller lots would probably increase habitat for wildlife, because wildlife are pretty excluded from the fencing right now. And the 5-acre lots are still going to be big, and it's going to create a smoother transition away from those sub-acre lots, rather than having a 20-acre lot right next to that sub-acre lot. And it's still going to be plenty of space to help with the proper well use and the proper septic systems. And there's still going to be plenty of space for maintaining that country feel, which is also right across the street. So yes, that's about all I have to say. Thank you.
All right, thank you. All right, so that concludes the public testimony portion, and we'll go into deliberations.
So commissioners, I appreciate Darren's comments because I think he understands the challenges that we face when we review a file. He's absolutely right. If there was an R20 zone and there was designations for that and standards for that, it would definitely help. The committee, the South Bonner County Southwest Committee, is definitely still working on their sub-area plan to address this, to address that issue and other issues, the growth issues. There's no doubt that the challenges that we're seeing, the pressures that we're seeing, there are no 5-acre lots in the city of Sandpoint. There's the growth pressures are definitely being felt around. And while I agree the smaller parcels belong closer to the cities, we talk of small parcels less than an acre. And so there's lots of the county that's zoned 5 acres, and it's definitely a concern as we go through these sub-area plans that the opportunity for all of those to split down to that, what does that look development-wise? challenges that we face is that the code limits us to specific review standards. And we address those review standards. The soil types come off of the USDA mapping systems, the NRCS, right? Thanks. Mapping systems for soils, and so the soil types, that's what we show. There are wetlands present. Some of those topics we delve into deeper when we look at a subdivision process. So sometimes a zone change and a comp plan change are higher up, 30,000 foot level. The actual development will dig into some of those issues better. None of those standards apply to this review. Traffic impacts, environmental impact statement, it's just not in our code at all. So we do have some standards that we look at, but they don't go that in depth. So based on the current ordinance and the review, the analysis that staff has put through it, it is consistent with the code.
Okay, thank you. So here we are in deliberation. It is interesting, the area, we've dealt with in the past up on the bench, so-called, from the railroad over to Flagstone and beyond to the west. And as you stated, that railroad is it's a dividing line. Taking down on Hood Lake and Kelso Lake and Range, which is a different character, except for old Flagstone. Thank goodness. I mean, if we could go back, I'd do some things that were done 100 years ago. Other discussion, thoughts?
Any well drillers reports? None of that.
No, and that's the interesting aspect of a comp plan amendment and a zone change, because it doesn't deal with what could be the eventual impact. Right or wrong, or they're uninformed, I don't know. But it's
And it's tough too, that is becoming the outskirts of Spirit Lake. It's not far from town.
And we have such odd-sized little lots, different things, because Flagstone years ago was plotted out.
Yeah,
it's just a unique little area.
So one kind of question. When someone applies for, let's say, the zone change, it has to be their property a defined lot, is that correct? They can't apply for half of it, quarter of it, or,
Oh, they could, we just have to have that legal description.
okay.
We prefer that not to happen because it creates a mess when.
Yeah, it's potential, and we've undone more of those in the last 5 years than we've done. Split zone, a parcel, an ownership is split zone. Yeah, any thoughts, Suzanne? Going into this?
No, I mean, it's pretty interesting just listening to the banter.
Okay, well, whatever you want to do with it. Just go ahead.
Can you overlay the critical wildlife habitat?
Oh, I can't. Yeah, I don't have a layer for that.
Oh,
I mean, it was an elk farm for.
well, that's,
Yeah.
I did like seeing the bulls walking around.
Yeah.
Yeah, that layer is no longer available in our mapping system.
okay.
Crash. Here's what I think it just went down. Okay, all right. Sure. Someone bring up a motion. Actually, you know what? It wasn't. Try that for. Go ahead. I think it just Brian. I'll look at the light on the text.
Commissioner Reed, I make a motion to recommend denial to the Board of County Commissioners on this project file AM0010-20, requesting a comprehensive plan amendment for the subject property from agricultural forestry to rural based upon the following conclusion. Okay, Jeannie, which, you need to read each one of those, do I?
Yes, you gotta read the conclusions of law.
Conclusions of law.
Based on the findings of fact, the following conclusions of law are adopted. The proposed comprehensive plan map is not in accord with the Bonner County Comprehensive Plan. The proposal is not in accord with the purpose of the rural residential land use designation provided in the land use section of the Bonner County Commission Comprehensive Plan. Conclusion 3, the proposal is appropriate, is not appropriate for the area based on the existing residential uses, soil types, access to public services, and maintain county roads. And I further move to recommend the following findings of fact and conclusions of law as amended. This action does not result in the taking of private property. The action that could be taken, if any, to obtain the zoning changes to. You can file a new.
Yeah, just go ahead and read those, but then you go back.
Okay, which one?
This one.
decision is based upon the evidence submitted up to the time the staff report was prepared and testimony received at this hearing. Does that cover it, Jean?
Okay, so we have a motion on the floor to recommend denial on file AM 0010-20. Is there a second? Is there a second? Okay, hearing no second, the motion dies. So we're ready for another motion.
Mr. Chairman, Commissioner Linscott, I move to recommend approval to the Board of County Commissioners on this project, file AM 0010-20, request a comprehensive plan amendment for the subject property from agricultural forest to rural residential, find that it is in accord with the general and specific objectives of Bonner County Comprehensive Plan and Bonner County Revised Code as enumerated in the following conclusions of law, and based upon the evidence submitted up to the time the staff report was prepared and testimony received at this hearing. I further move to recommend the following findings of facts and conclusions of law as written. This action does not result in taking private property.
Now we have a motion on the floor to recommend approval to the Board of County Commissioners of file AM 10-20. Is there a second?
Commissioner Glasso, I'll second it.
Okay. Motion and a second to recommend approval. Any further discussion? Hearing none, all in favor of the motion say aye.
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 Any opposed say nay.
Nay.
Okay, the motion passes. So we will be recommending approval for the comprehensive plan amendment. That brings us to the zone change. And the zone change was heard simultaneously, so we have a motion for the zone change.
Chairman, Commissioner Linscott, move to recommend approval to the Board of County Commissioners on this project, file ZC 0007-20, requesting a zone change from Ag Forest 10 to R5, finding that it is in accord with the general and specific objectives of the Bonner County Comprehensive Plan and Bonner County Revised Code as enumerated in the following conclusions of law, and based upon the evidence submitted up to the time the staff report was prepared and testimony received at this hearing, I further move to recommend the following findings of facts and conclusions of law as written. This action does not result in the taking of private property.
Okay. On file ZC 0007-20, we have a motion to recommend approval to the Board of County Commissioners. Is there a second?
Commissioner Bailey, I'll second the motion.
Okay. Motion and a second to recommend approval on ZC 7-20. Further discussion on the motion? Hearing none. All in favor of the motion say aye.
Aye.
Any opposed?
Aye.
Any opposed say nay. Okay, the motion passes. So that finishes that file. And we now have zone. Oh, yes. Well, the result of that is it can be appealed to the Board of County Commissioners. And, yeah, that was stated.
Still comes a hearing with the board.
Right, it would have to be a hearing anyway before the board based on our recommendation. So that'd be the next place to be.
And how would we know when that's going to happen? Because a lot of us weren't notified at all about this.
Well, it'll be advertised in the paper, in the B. It'll be on the county website.
It'll be on the county website?
Yes.
Okay.
If you look at planning, then there's one tab that's called hearings. Hearings or agendas, and under hearings, it'll be agendas for both the county commissioners and for this body. So it'll be there.
I'm sorry, what is the time frame usually involved?
Within, they try to schedule them quickly, so within the month.
Within what?
Within the month, within a month from today. Usually, if they've got room on their schedule, they get it out 2 or 3 weeks out from our recommendation, which they'll have in the morning.
Is there anywhere else that we can find out? We don't get the.
Well, the website, if you, yeah, look on the Bonner County website under planning. And that lists both the commissioners' agendas and the planning agenda calendar. Okay? So, sorry, we jumped into this one before explaining that, so. There we go. Thank you. So at this time, we're taking up ZC 0008-20, which is the Stevens zone change. Haida Hope LLC, Michael and Teresa Stevens, requesting a zone change from rural 5 to recreation. So any conflicts on this one? And hearing none, okay, let's go with the staff report then.
All right, thank you, Commissioner. I know it's getting late and we still have a workshop, so I'm going to move through this really fast, and I don't want to rob anyone of any information, so if we have a public debate, we can get into it. So the applicants are requesting a zone change from rural 5 to resort community, to recreation. Their comprehensive plan designation is already resort community. So currently the zone is out of compliance with the land use designation. So they're requesting to move to recreation, which would also fix the land use and the zoning matching. So that's the gist of this one. This is a current site plan of the parcel. We have a duplex on the property and a shop, and then also an existing tiny house, which is a mobile home. The parcel is about 13 acres and it spans across Highway 200 and Hope. So this is pretty close by to some other recreational zoning, as well as the marinas and other sorts of rec type businesses. Some site data, it's currently a residential parcel. It's unplatted. As I mentioned, it's 13 acres. We're zoned rural 5 and we're comp planned for resort community. Both parcels are legal per instrument number 693701. So the site does feature some wetlands, but it does not contain frontage on the lake. There are no map slopes. The standards review for a zone change is to make sure that it's in compliance with the comp plan. We know that by requesting the zone change to recreation, the resort community does allow for recreation zoning. So we're looking to bring this parcel into compliance with the comprehensive plan. We routed for agency review on May 19th. We received a lot of no comments. I think actually we received all no comments. We did not receive any comments or public comments on behalf of the zone change. So rural 5 requires 1 dwelling per 5-acre density. Currently the property already exceeds that, so we're not even meeting the recommendations for the R5 zone. If we look at the proposed zoning for recreation, it requires frontage on main roads, sewer and water services, fire services. The property is serviced by Samoan Fire. We've got Ellisport Bay Sewer and a well that produces 100 gallons a minute, which is sufficient for these criteria. Again, we're looking to bring this into compliance with the comprehensive plan, and we do have the adequate services available. So the findings of fact for this property are that we have that 100-gallon per minute well. We've got a parcel served by the Ellis Bay Sewer District. We've got highway frontage on Highway 200, and we're looking to bring the parcel into compliance with the current comprehensive land use designation. At this time, I know I went through that really quickly. It's a very straightforward zone change. Does the commission have any questions for me?
Any questions for staff? Okay, thank you. And now, do we have an applicant?
Yes, we're here.
Okay, all right, thank you. So if you would, if you care to add anything to that.
Thanks for giving questions. Happy to answer them.
All right, so any questions for the applicant? All right, and do we have anybody else in the room who wants to add anything to this? Okay, so there's no reason to respond. Okay, so we'll close the public testimony portion and open up for deliberation for this zone change.
I think there's anything to deliberate.
Yeah.
It's pretty cut forward.
Bring it into compliance.
Susan, have any comments?
Anything, Suzanne? Any thoughts?
No, it seems rather straightforward.
Okay. All right. So looking for a motion.
Commissioner Bradish, I move to recommend approval to the Board of County Commissioners on this project file ZC0008-20, requesting a zone change from rural 5 to recreation, finding that it is in accord with the general and specific objectives of the Bonner County Comprehensive Plan and Bonner County Revised Code as enumerated in the following conclusions of law and based upon the evidence submitted up to the time the staff report was prepared and the testimony received at this hearing. I further move to adopt the following findings of fact and conclusions of law as written. This action does not result in a taking of private property.
Motion on the floor to recommend approval to the Board of County Commissioners for project ZC0008-20. Is there a second?
Mr. Chairman, Commissioner Bailey, I'll second Mr. Bradish's motion.
Motion and a second on the floor. File. Any further discussion? Words up. Hearing none, all in favor of the motion say aye.
Aye.
Any opposed say nay.
Aye.
Thank you. So we will be recommending approval of file ZC0008-20.
Hold for 5 minutes.
I went really fast. I hope that was okay.
Okay, so there you go.
So we need to take a break, so some staff.
Yes, so that ends the public hearing portion at 8:37 on August 20th, 2020. Phew. Thanks for hanging in there, guys.
Can we take a second break?
Yeah, let's take a little break, 2 minutes, come back about 8:40. 8:40. Oh, let's stretch it till 8:45 if we have to.
Tomorrow morning.
Okay. I'm gonna try to.
Don't question it.
No. Is that what happened? You think it was?
Oh, I think it's fine.
Run into your cord?
Still thinking about it.
Oh, well,
That's right. We didn't let Charlotte talk.
I've got the state flag down there.
See the little spider up down there? I didn't.
What's going on down there?
That's awesome. I didn't, my book, that's a rough neighborhood there.
What's that? That's a rough neighborhood. Oh, yeah, yeah. We find RVs and cars up almost weekly now. It's getting bad, especially on Hoover.
So like there's kids up on there alone. I'm going bass fishing if I get the bass over that fence.
You got it.
Pack River Road in southern Bonner County.
Hey, I heard you guys are into towing trucks.
Towing trucks.
We heard Scott, they were standing on a trailer, some guy came around and drove his truck up on the trailer, is that the story?
That's the second time he's got rear-ended this summer. Yeah.
Oh.
He said he's got a target on his back, I guess. Did you see a picture of that little rig that hit him?
No. Who told me?
And opened that thing up like a can opener.
No, I think it was Danny from Torque. Because they were coming on just right after that.
At night? It was on South Single Road. He pulled off to the side. They were putting in a driveway there. They pulled off to the side to unload some culverts. He had his four-way flashers on the pickup on, had his, whirly lights on. There was a car come around him, and another guy come up.
So his truck Anderson's.
Yes. Yeah, he took it there to get his trailer worked on. fix it, get an estimate to fix the trailer. So he actually kinda
Military dump truck.
shoved it down.
Well, that's your own right.
And it's
I actually bought that out of the unit that I was with, and they came back from, Kuwait.
Really?
They liquidated all those trucks.
Yeah,
They
there's gonna be
shipped
more than-
millions of dollars to ship them all home. And as soon as they got them home, they.
George Harris.
Yeah, we did the same thing.
County over there.
Go around over there.
County water truck back.
Everything was brought back and
Keep the same, yeah.
Robert. You know, because when they brought everything back, they washed everything with salt water. Really dry. They wasn't- they just didn't want to leave anything behind. I know he said he was that day, but he-
I asked myself why I agreed to do this. Oh, sir.
Oh, Matt, what did you do?
I wish I could say something cool like a motorcycle accident, but I had knee surgery a couple years ago. And if I ever do something stupid on my knee, like I was putting irrigation pump in and piping, and just up and down on my knees and doing fitting all day Saturday. It didn't even bug me Saturday night. Sunday morning, it was like,
What he's trying to say is he's not 25.
None of us are.
That's for sure.
Well, these ladies probably.
can we hand these out?
Yes.
Kick them in the other leg. You know what I was wrong with you sitting at your desk for the last year and a half.
Sorry about
Dude.
All right, so it is now 8:42, and we're resuming our meeting, and we're now in a workshop.
Went on.
So it's a little looser than the hearing, but we're still here. And I know there's people online who are listening, so sorry for the delay.
Oh, yeah.
So,
Do we have the floor?
and we'll get to you now.
Chair?
This is a workshop of the Planning and Zoning Commission.
Okay.
And I appreciate that people are here in the room for this and that people are online. This is a workshop. And the way the rules are set up, we don't have to take public testimony at a workshop. And at this point, I think that's the way we're going to go, not have public testimony tonight. At some time in the near future, when advertising is done correctly and files are formed correctly and everything, we will schedule there will be a schedule for a hearing with the Planning and Zoning Commission, but that is not established at this time. Yeah, and people are submitting written comments. That's good. Continue with that as you will. Those will be, we can look at those tonight. They will certainly be part of the record for the hearing. The hearing will be advertised duly in the paper and on the website when it's scheduled, but it's not scheduled anytime immediately soon, like next week. Okay, so we have a code section 2.7 look at in this workshop tonight, and we have a staff presentation to let us know what it's all about.
So I'm going to turn it over to Haley in just a minute. I just wanted to do a brief overview of where we are. I don't think that the publishing was done wrong. I think the publishing is fine. We just decided that we wanted to allow more comment and more input into this ordinance. I appreciate that folks are interested and want to have some say in this. It's unfortunate that sometimes those comments are simply to reject the idea because we can't just reject gravel pits in Bonner County. There needs to be a solution that makes sense for everybody, and going down the path that we have been, again, you're seeing the demands increase and growth increase, and so we're having to address some of those demands. 3 years ago, when we started this process, we talked about rezoning gravel pits to industrial. And in order to make them be what they are on the ground, the challenge with that was that there's a lot of unintended consequences with that. If we were to zone a gravel pit industrial, there's a lot of other uses that are listed as permitted in the zoning code that would then be all of a sudden permitted in the gravel pit that didn't make any sense. At the time, the ordinance actually allowed rendering plants in the industrial zones. We've since taken that out, but my point is to show you that the industrial zone allows a lot more uses than what we're intending to address. And so we're trying to identify a code that addresses gravel pits and its accompanying uses that makes sense. That makes sense to both the landowner and to those neighboring it. Our intent in coming forward with this document a couple months ago was to provide a framework for discussion on how to do that. I think we've created that discussion. We've had some good meetings outside of here with landowners as well as with the commissioners. So the purpose tonight is to finalize, not to finalize, but to show you where we are and continue to move forward down this path that makes sense. Again, we're talking about gravel pits and its accompanying uses or associated uses that make sense in a gravel pit. So Haley's the one that's been putting this together for us. Okay.
I'm Haley, planner with Bonner County Planning Department. Little overview about the proposed changes and a quick summary of their intent. We're proposing a new administrative procedure called a Certificate of Zoning Compliance. The purpose of adding this is twofold. And the first one is to verify legality of land uses and development and structures, just as our existing procedure of a certificate of compliance verifies the legality of a lot or parcel at the time of its establishment or creation. We're just making a process now that does the same thing for land use and specific structures and development. The second part is to provide a review process for those uses with specific and thorough standards that are outlined in the ordinance, basically addressing the concerns that would come up in a public hearing process, and therefore can proceed on with an administrative decision. So we're also proposing modifications to the existing ordinance with regards to mining, rock crushing, and batch plants, which is going to be proposed to be renamed to non-metallic mineral processing plants, and I'll get to that reason in a minute. We want to propose these amendments to provide clear standards for operation of these uses while ensuring that the uses will be in compliance with state and federal regulations. Currently, our standards are revolving around like emissions of noise, light, glare, smoke, odor, dust, all that stuff. Those standards are vague because they're subject to the conditional use process. And those vague standards can lead to potentially arbitrary conditions or rule sets to be set in place during a public hearing procedure and attempt to satiate public concern. So what we've done is we've solidified those. However, the permits and plans required by state and federal agencies have much clearer standards. And they also have the powers and means to enforce those standards as well, where we don't have the equipment or the tools to enforce certain things with regards to health, safety, and welfare. It doesn't make sense for us to regulate those authorities who have the required expertise and standards in place for those aspects. We've routed this to several agencies. We've got some comments from Kootenai, lots of comments from the public. We've also got some suggestions from others on changes that need to be made. Let's see, what else is there? Let's go ahead and go through the changes proposed. So everything in red is the original submission. And everything in blue is what's been proposed since and what we really, how we try to beef up the ordinance and what we're going to be reviewing mostly here. So for the first part, in the certificate of zoning compliance procedure, we did basically create this chapter from scratch, sort of resembling the conditional use permit process. Some of the things in blue is just renumbering that wasn't caught on the early onset. And additionally, we needed to clarify the terms. There was a mixture of certificate of zoning compliance and then zoning certificate. We settled on certificate of zoning compliance because we're certifying compliance with the zone. We're not certifying what zone you're in. So we want to make sure that was very clear with the verbiage. Let's see. We also added G. And this was based off of some suggested language that allows like permissive language to give people a chance to basically resolve their violation if there is a claimed violation, instead of just making the use null and void at that moment. We want to give the landowners a chance to make it right. The application contents very much resemble that same thing of a conditional use permit, just basic information. And the important part is letter L, which allows us to obtain information such as reclamation plans and other permits that they may have received to establish their use and verify that they were in accordance with the law at the time. And let me know if you guys have any questions at any time. So in the second part, the standards of review, A was added just to clarify that this is not just for existing uses, but also for new uses of development. The goal is to eventually apply this to those accessory structures, again, with the specific standards, as well as verifying previous uses, previously established uses. And again, some of the blue is just making it consistent, the term. Let's see. That's just a regurgitation of what I said earlier. So that's kind of the end of this component here for the procedures, standards of review, the appeal process, things like that. So is there any questions on the first section?
This is the A on 273, because this applies to everything.
Yes, anybody in the county can apply for one of these regarding a previously established use if they are not sure if it was established legally. I want to give people we have a lot of people asking us, well, was this legally developed? And we don't actually have a formal process to do so. Now, we can certainly do the research, but it's better to do it as an application if we're going to be spending our time doing this research.
So I thought there was in existence a certificate of compliance.
Yes, and that's for the legality of a lot or parcel, the
Right.
creation of a lot or parcel, but not the development upon.
Not the development, okay.
Correct.
So it would seem to be similar in that sense,
It is similar.
because it's checking into the legality of a situation.
Right, and it has a single date that establishes legality, and in the case of uses, it gets a little bit more complicated because you have to look back at the ordinance, the original ordinance, also state law on the grandfathering laws and things like that.
Okay.
Any other questions for this particular section?
Got any?
Okay,
Oh, yeah, we're still reading, so.
okay.
I'm kind of
Did I go through that
digesting.
too quickly, guys? I'm
Yeah.
sorry.
It's really good.
What's that?
It's really good.
Yummy. Yummy. Well, and that's, we have Scott online by chance? Bauer?
No.
Oh. I saw Scott there. Because there is a couple questions on this that I do have.
Now, the
And it's on A.
On which number? 273?
Yes.
Okay.
Request the planning director to determine whether the use and/or development complies with the applicable provisions of the code in effect at the time the use and/or development occurred. I'm assuming that what that means is when it started.
Correct. We would apply the
Yes.
laws and regulations at the time of its establishment.
Get that snapshot of time.
Okay. And then the second question I know because we are doing with grandfather, a lot of these pits are grandfathered. So if you go to 12-340, in 12-341 or
No, it's not, there's no.
That's on the code.
There we go.
Because it says on 12-340, the intent on non-conforming uses and structures. Characteristics of uses which were lawful before this title was passed or amended, but which would be prohibited, regulated, or restricted under the terms of this title or future amendment. Is the intent of this title to permit these nonconformities to continue as required by law? I think it's going to be, and then I know a lot of people bringing up 12-341.
So do you understand that what that just said though? We're going to verify, this is going to verify that that use was established properly. And then we're going to, and then that allows it to continue.
Right. And I guess my question, I guess where I'm getting at this is, what date are we using? I know there's a lot of, there's some comment in 12-341 regarding the accumulated expansion of 10% in the commercial, industrial, and public use. Well, we're talking resource use. That was established prior to December 9th, 1981. Here's where the problem that I see. You know, and I'm just reading Bill Wilson's brief that was just submitted 2 days ago to Idaho State Supreme Court. Subsequently enacted ordinances are not given retroactive effect, and the ordinance effective at the time of application is definitive. And so when he goes on, it says a common justification for the theory that a landowner's rights vest upon application is that landowners need certainty and should be protected from municipals seeking retroactive application of a later enacted ordinance. You know, we have a little bit of a language in there that is going retroactive, and I don't think we can do that. I think that was misguided when that was put in there.
Well, it was, so that, I understand what you're saying, and it's an interesting question. The non-conforming use code. And that's why we ended up changing the dates in 616, was because of this code here conflicted with 616. And so the question is are we creating that conflict? If we're gonna say that it was created at the time it was created, it was non-conforming or legal. But this is what he's saying here is this is saying that as of 2008, this is all considered legal non-conforming.
Because there was a lot of things in that commercial, industrial, and public use that probably have grown by 10% because they started part in 1981. However, this language in this code was not adopted until 2008. So they're putting retroactive language that should never been.
So you're saying 340 conflicts with 341 is what you're saying?
Yes, and because when we have these letters from our own county attorney saying that we cannot, be going ahead and going retroactive on these ordinances.
Except for the code does call it out. I mean, it does call it out pretty clear.
It does, except for the problem is November 18, 2008, when this was adopted. It was adopted through ordinance 501.
Oh, I understand.
And it eliminated in its entirety.
But that's been, this code has conflicts with itself throughout.
Yes.
That is the challenge with this thing.
Yes.
Okay.
So now that it's further recognized,
we just need to add 340 and 341 to our list of things to change or update.
Yeah. Okay.
That's why we have public comment. Absolutely.
Because if we take a look at 12.340 and we go through the rest of this document, we're going to get there. There's many things that conflict with 12.340 that we need to take a really close look at.
good. Well, it's that broader language than just the mining, so that can fit a lot of, all kinds of lots.
That's good. So just note that.
Yeah, I put a comment in here at 341.
Well, and your letter A, your letter A is gonna have to. Be, it's gonna have to say provisions at the time of use of development. It's probably gonna have to say something, right? About 2008. So we'll do some more research and look into that one further. Well, it's a really slippery slope because 340 talks a lot about the date of this code, the date of the adoption of this code. So by adopting an amendment to that code, you automatically change those dates. So you have to really be careful with that code.
Right. I see what you mean on 340. On 341, though, I think it's a little bit different.
Oh, I get it.
Alan is purely the date of that date, December 9th. Okay. So a little more look-see on 340 and 341. All right.
Okay. So the next part that we have are the use tables. And so if you look at letter D under 12-330, we're applying new symbol Z to represent the zoning or the certificate of zoning compliance. And so that language is just basically the same as the other ones above, except there's a Z now. And then it references subchapter 2.7, addressing the new chapter for its procedures. So as we go to the resource-based use table, you'll see some changes here. We've got permanent mines, temporary mines, and then we renamed batch plants to non-metallic mineral processing plants. And the reason we did that is to match the term to the IDAPA regulations that are regulated by Department of Environmental Quality. So instead of having all these mixed match terms, because we're asking for the same permits that they're going to be issuing, we just decided to adopt their term and their definition. And we'll go down to the definitions shortly to show what's new. And because we did that, we also removed number 22, that subnote, which says a batch plant shall obtain a certificate of zoning compliance. And I believe that was in the original set of changes, and now we're removing it. Because we now have a section that is specific to batch plants and those processing plants. Before, we just had a specific section for mining, but now we've put 2 of them for those uses. And part of the proposal as well is to remove rock crushing operations, to not leave it as a separate use because it's inherent to mining and gravel pits. So we felt it made sense to just remove it as a separate use and just to have it combined. Additionally, since then, we've changed some of the subnotes, 21 to reference the specific standards for non-metallic mineral processing plants. And then subnote 10 is just referencing the mining standards for, the respective uses in that table. So I'll let you guys go ahead and go through that and then we'll go through the questions.
I'm a little confused that the permanent on your use table, that your permanent mining, stone quarries, gravel pits, stone mills, why wouldn't that also be with a Z? Because we're talking about permanent mines that have been in place for over 5 years. Am I thinking correctly there or not?
No, we changed that definition. Also, the permanent mining stone quarries in this use table are for brand new mines. It has nothing to do with existing ones.
Oh, where does it say that?
That's how it's always been applied, all of our use tables.
Yeah, we don't go through the code and say, oh, there's a store, we need to go make them get a conditional use permit. It's already there, right? Non-conforming use, right? We don't make somebody, we don't apply this retroactively.
No, but
what am I missing?
well, I'm looking further down because K under 482.1 says all existing service mines must receive a certificate of zoning compliance within 1 year in order to maintain the existing non-conforming status as of the date of this ordinance. So
Matt, do you understand what we're trying to do?
I understand what we're trying to do. I just want to make sure that I'm reading it correctly. So.
Right, is what I agree. That's good for the discussion. Is we want what it says to indicate what we're trying to do.
Yeah.
Right.
And that was part of the question we talked about yesterday, was make that really clear when an owner would need to get a certificate of compliance. And then that's backed up by who or what. So where it says here in K, all existing surface mines, is it purely all, or is it those that are in non-conforming status?
And that's kind of my concern is the way I read that.
Yeah.
To me, it makes you think that existing grandfathered rights have to go back and get a conditional use permit that all existing service mines must receive their certificate of zoning compliance in order to maintain their existing non-conforming status. And that's where I'm going back to 12.340, is that the way I interpret that is you can't restrict.
We're not asking you to go back and get a conditional use permit. What we want to know is we want to verify for the gravel pits what is there. So we're going to draw a line in the sand with this ordinance. We're going to say, right now, we're adopting an ordinance that's going to affect all new gravel pits. So we want to know what is existing on the ground right now. So we want every gravel pit to give us a zoning certificate application so we can verify that everything on the ground right now complies since 2008 at least with what we're going to adopt today. So we can verify that that gravel pit is indeed in compliance with the code.
So that's gravel pits that are in use, not the ones that are sitting there stagnant.
And so if there's a better way to say that in the code, then tell us. We'll do that. That's what we're looking for, though. is.
So even there under K, if it said all existing operational surface mines? I don't know how you say that.
Well, I got an open pit next to us that's been,
Yeah.
it's been sitting there for probably 50 years.
Yeah. And
Is
is
it
it
an
that
operation?
one thing that said,
The landowner has used it for his personal use.
Yeah.
It was used, what Taylor said, it was used to build a road from Colburn over to Samuels.
yep. And there's lots of those. I can think of 2 county pits that are that way.
Well, then there's the other one on Colburn that's, been staying there too, that needs to be finished so they can straighten the road out, so.
Oh, yeah.
But that's beside the point.
That's beside it. Someday. Yeah, and so it's maybe just a little, I don't know, deciding the words to clarify it, to make that point.
So are you okay with the idea of what we're trying to accomplish?
Oh, I
You just
totally
want
am.
it to be, okay.
I totally am, totally fine with that, but as I'm looking at those, just say hypothetical, you have a grandfather pit out there that says, I'm not gonna do anything, I'm not gonna go get that certificate of zoning compliance.
Exactly.
And according to K, they're no longer gonna be able to maintain that existing non-conforming status.
That's correct.
But if you leave 12.340, if you read 12.340, again, it states the characteristics of use. Characteristics of use is a gravel pit, which were lawful before this title was amended, but which would be prohibited, regulated, or restricted under terms. It is the intent of this title to permit these nonconformities to continue as required by law. And so as I read that, and then go back to here, it
So we'll
says,
change that then.
what's that?
We'll change that then.
Yeah, just make it,
Aside.
make it copacetic with that other.
I asked, did you understand what we're trying to do? And what is the path to get us there? If you don't want us to do what we're trying to do, then say that.
I agree that we need to do something. I think you're going down the right path.
Okay.
But until I understand this better, because I'm not understanding and getting to that point yet, it's almost better not to do anything at all. In some respects.
Yeah, it's gotta be clear.
You're right, we shouldn't change it.
No,
I'm just.
All right, we're here to push the buttons and make sure that what's going forward, whenever, to the hearing before this body, the thing reads well, everybody understands it, and there's no these questions. So that's why, we met yesterday, just talking the thing through. I can't remember all the questions I asked, but there was a bunch, and anticipating those questions are going to come from this group, and they're going to come from the other citizens out there who are next to it.
Absolutely.
So we got to figure them out. So we can't.
That's why I'm asking. Is if
Mark, I don't want to take any problem.
Are we interested in drawing that line in the sand? We would like to, it would be nice to have every gravel pit verified as legal, non-conforming, whatever, a piece of paper that verified that, recorded in the recorder's office.
Yeah, so
That they could bet on forever.
And the neighbors can see it to say, yep, that's legit. Well, he did, but I'm not going to recognize it.
Yeah.
I'll just blurt out something we can know.
I won't touch you as you're going out the door, okay?
There's telepathy going on. I can feel it going
I know, I
on.
can.
So
They got eye contact.
But
Well,
right
So
I know, but.
Are we talking grandfathered pits, or are we talking the pits that are under conditional use permit, or I'm confused?
Well, those are, so, and that's the whole thing with this K item, K footnote. And that was my leading question yesterday when we talked about it. Who does this apply to? So that needs to be super clarified. And I agree with what Milton's saying. It just needs to be a complete listing. I mean, here they are, any that are known in the county, what the condition is, where they came from, so that anybody can look, so the owner can have surety is what it is, and the neighbors can have surety of what it is or isn't. So, yeah, I mean, it obviously puts a burden on the owners to
start this process. Maybe that's the other thing, just for kicks. How long, what investigation? I mean, you talk about researching records to see what the zoning was at the time, what all the conditions.
Well, I mean, that's a perfect example. So for example, somebody came in and got a conditional use permit. Do we even know if they've expanded that gravel pit and the parcel numbers changed? And so things change. We don't even know any of that stuff. And so that's what I'm saying. We need to know what's on the ground right now. And then we can move forward with a code that makes sense. And that's what this is trying to attempt to obtain is.
It's not necessarily leveling the playing field, it's just knowing what's on the playing field.
Yeah.
What's out there. And you know, we've seen various things. I think even the article in the paper said something about a number that came from planning. Some 197 or whatever the number was.
Came from Department of Lands, I think.
No pits in Bonner County. And I wouldn't go to the bank on that number either.
I wouldn't either.
There's so many, big grief. Like I said, I know of 3 in my neighborhood that don't show up on anybody's list. So, yep, all right. Well, so we're at the use table.
Yeah. A couple of extra things to know. If you look at subnote number 21, you see the cross-out portion for the best practice operations, need to be the best available technology.
Yeah.
It's not truly going to be gone. It's moved to the specific standard, so I wouldn't worry about that being removed. Additionally, 23, that's the definition of an open pit, and we just moved it over to the definition section because it makes more sense to have all your definitions in one place instead of, you know, sporadic throughout the ordinance.
Especially not buried in the footnote.
Those are the proposed changes. You'll have to ask him if he's accepting public comment at this time. So.
I don't think it would be fair, Brian, because we got people on the phone too that are Brian and Brian. So, but certainly put your comments in writing and get them in.
Well, we'll probably hold a couple more meetings with the public.
Yeah,
we probably with the industry as well as with the public. So, and then we'll have another workshop or two here.
Okay, so I mean, this is a very important issue. It's, as I see it, and I think it's been explained tonight, it's trying to find a path forward to get everybody, like I said, on the playing field know and the status of it all. So okay. All right, so we're ready to go into.
Ready to go into mining, the specific standards?
Yeah.
So we added a purpose statement, basically to provide definitions for temporary versus permanent, because we create new subcategories for surface mines. We also wanted to make sure that these standards are now consistent with the goals and policies of the comprehensive plan, to establish mining standards that are consistent with other local, state, and federal regulations as required. And then that the, let's see, I feel like C and D need to be saying the same thing, so we may need one of those. Oh, to establish and then to ensure. Those are the main differences in those statements. And then the applicability section. So all of those that are defined in as mining under 813 and then open pit and 815 are going to be, and further defined herein, will be applicable to this section. And we have our general standards here that for all new mines, that we would get a copy of the approved reclamation plan from the Idaho Department of Lands. And that typically includes a stormwater plan. They also collaborate with DEQ regarding, I believe, with air and water pollution where it's applicable. So they may not always be included, but they will be included where they're applicable. And because it's in our comprehensive plan to have stormwater plans for land disturbing activities. Should the reclamation plan not require a stormwater plan, we have two options. Either they provide an NPDES stormwater permit. Those are typically applied to those land disturbing activities 1 acre or greater. And if it's still not subject to that one, that just defaults to our regular stormwater code that's existing in our ordinance. We want to make sure that we're still applying those goals and objectives that are in our comprehensive plan to these uses. We're proposing to take out E, that the mined area should not be closer to the nearest property line. There's a lot of discussion on how there's a lot of valuable real estate that could be mined in those areas. And that's something that I'm going to let you guys sort of discuss on whether or not you truly want that removed, or if you guys want a different setback or something along those lines. I also couldn't find the research behind it to state or why it states this setback. That's another reason why it was proposed to be removed. And so if we go to E, F, and G that are now removed, the fugitive dust control has been removed because it's already taken care of in the reclamation plan. They're going to collaborate. If there is an air pollution permit that's needed, it will be obtained. We will still have a copy. So it's a redundant factor. And then the applicant shall comply with all requirements of the reclamation plan. I think that goes without saying because we're requiring the application and that we're going to be making sure that it's approved. So if there's any activity that is outside the reclamation plan, the public is more than welcome to submit a complaint. And if we don't have the power or the ability to enforce those regulations, we will defer it to that state authority and they can pursue it. We've also discussed that we would also talk with the landowners to make sure that they had a copy of that complaint, that they were aware of it, so that if there was any action that they need to take, they have the opportunity to do so. And then the standard all retail materials on site are prohibited. We moved that to a specific standard, so we just took it out of this general section. And everything in black is what was previously already in the ordinance for this particular use. We changed up I a little bit. Instead of saying to the satisfaction of Bonner County, we're going to make sure that the hazard fencing or signing or other health and safety standards are going to be to the satisfaction of the Mine Safety and Health Administration, or MSHA, because they are the regulators on that. We don't want to double duty those standards. K, I think we've gone over K sufficiently, so I'm going to go ahead and leave that one alone. So when we go to the standards of review for temporary mines, these are the specific standards. And temporary surface mines are now defined as those surface mines that are operating to serve public projects, and that they could be within the private sector. So if the private sector is in contract with Bonner County or the state for a project, they can be classified as a temporary surface mine because their services are going to be inherently temporary. We're also allowing non-metallic mineral processing plants during that time, but we are removing the retail sales of materials on site for those types of uses because they're supposed to be serving the public and not for retail sales to private citizens. And then for the standards for permanent mines, those are just surface mines. Let's see. Basically, it's just the regular surface mine definition that are operated by the private sector and they serve the private sector. And we can change the verbiage on this to better reflect the applicability. Let's see what else. Oh, and then it states that the accessory uses for these permanent mining operations, they would obtain a certificate of zoning compliance, and that's also stated in that use table, everywhere it says Z. So like the non-metallic processing plant they decide to add that on later down the road, they would just apply for one of those certificates. Retail sales will be allowed on the site. Processing plants will be allowed on the site. And rock crushing operations and blasting are permitted. The part in blue that says "and blasting" was suggested to us by the public to add some detail as to the operations that are allowed. Part of the struggle is if we get too specific, then anything that we missed in the specifics is now inherently prohibited. If we leave it vague, then it's kind of like a free-for-all. And so I definitely recommend some deliberation or a conversation regarding how specific we really want to be, because we could inherently limit some of their operations accidentally. So let's go ahead and start with this section. We'll go on to the batch plants in just a second.
Okay.
So maybe under C, drilling, blasting, crushing, and screening. Those are pretty much.
Okay, does that language limit the types of trucks or?
No, that's the heavy equipment that's used. Gotta go in and drilling or blasting makes a lot of noise. Blasting makes noise. Crushing makes noise. Screen pit or screening down smaller stuff. Doing sand, that makes noise too. And I think that's pretty much covered it. Gonna have trucking.
Right, I just want to make sure that the language doesn't.
So do you want those suggestions now? Or you-
Yeah, let's talk about it.
Oh, I absolutely agree with Brian.
Yeah, broaden out the list, and you're right. I mean, you know, you make a list, it's on there, what if it's not? So I think let's put it there now, and then when we have a talking workshop with industry, they can fill us in on what we missed.
So you could put heavy equipment operation in there for the vehicle.
Yeah, I think we could
Vehicle and track.
probably flesh out that definition pretty well with the industry folks.
Yeah.
Oh, heavy equipment operating.
Well, you got a dozer, you got wheel loaders, you got rock trucks, water trucks, so yeah.
What about
There's gonna be-
mechanical repairs, right?
Pardon?
Mechanical repairs?
Yeah, on-site repair. There's a bunch of stuff. Fueling, you know, again, a lot of the things are regulated by the state
MSHA,
agency or MSHA. So we need to get that understood and get that cut line.
Right.
Even making that statement, I think payroll. That's the installation of fencing, warning sign. Yeah, I don't know, maybe it could be broader here.
Yeah, if you look at the comprehensive plan on the last page, I copied and pasted the specific mining components. And some of them, the term mining is also used in the broad sense to include quarrying, well operations, milling, crushing, screening, washing, flotation, and other preparation customarily done at the mine site. So that's why I wanted to know if we should add this list or if we should leave the comprehensive plan as the interpretation.
Are we still on, okay, we're on C.
On the last page.
Oh, I thought, my bad, I thought we were still under 1242.
No, I'm quoting the comprehensive plan economic development section, and I put that on the last page of your packet.
I guess the one question I have back on 4482.2. Can we go back there? I was looking at this, so. Non-metallic mineral processing plant shall obtain certificate of zoning compliance and shall only be permitted in association with a permanent gravel pit. The problem with that is all these temporary pits need a crusher too. So to say that those crushers or screens or whatever, and shall only be permitted in association with a permanent gravel pit, I think is an error.
Which section are we on? Because I'm on mining.
Oh, 482.2.
I haven't gone over that yet. I cut it off at that other part. We can go over that, certainly, absolutely. But I wanted to get comment on this one so that I don't get overwhelmed.
Okay, I'm sorry.
So like most asphalt plants, they reclaim asphalt to get the, with 7% oil back out of the material. They're gonna have a crusher and screen in there, so they can repatch that material back into their operations.
Yeah. Yeah, you drag that into the definition.
Well, see if we're throwing something else in here now that's not in the definition.
References it in the comprehensive. In the clumb bed line, whatever that is.
There's still, yeah, there used to be line plants. I don't know if there's still lines.
That line?
Other side of the lake. Yeah, it's over Lakeview. Yeah, that's where the old line was.
Some exploration over there.
Move that over where the concrete.
You got an observation.
Yeah, yeah. Somebody was up there doing exploration.
We let them drill it there.
Right.
2 years
Right.
ago, right?
Never heard anything about it since?
And so the other thing here is we come back to stone mills. Are we kind of looking at a stone mill or the like gathering the rocks like they do in Clark Fork? Is that?
Right. I had that. Tabletops.
Yeah, just what they're mining off the rock.
It's included because it's in the comprehensive plan. That's all encompassing mining activity.
Yeah, I had.
To take that out was deviating from the comprehensive plan.
Yep. Understand. Yeah.
However, when they rewrite the comp plan and catch this stuff if it's not, not there.
Right.
So where are we now?
We'll go on to the batch plant portion, the specific standards there.
Non-metallic
Yes.
mineral processing plant.
Right. I'm saying that in the colloquial sense. But the technical term, if it's accepted, is going to be non-metallic mineral processing plant because it's the same term used in the IDAPA regulations. We restated the purpose. Basically, it's the same purpose as the mining one, except we just are now applying it to the non-metallic mineral processing plants. Same thing with the applicability, copy and paste it, just substitute terms. And then letter C are the general standards. So right now, one states that the operation shall be located outside of areas of city impact. So it's been suggested that we remove that because right now those areas of city impacts are rather wide. And did you want to expand on that a little bit, Milton?
Yeah, there's several gravel pits that are already currently inside areas of city impact. Afraid that we're going to do something to impact that. We don't want to. And so, plus we're also in the process of starting to renegotiate. We've reached out to Soundpoint and Dover to renegotiate the areas of city impact. Waiting for a response from them to start that process. And then we are meeting monthly with the mayors. So of all the cities, if they would show up, the board is having a monthly meeting with the mayors. If they would come to the meeting, they could participate in some of the stuff that's going on. It gives us a chance to, again, work through this process. So
how does that work for those grandfathered mines that are currently in area city impact? Right, because they are definitely going to use crushers and stuff in there, but as that says right there, operations shall be located outside of city impacts.
yeah, I'm just afraid that by putting that in there, it's going to impact them on any new stuff. The grandfather stuff is good to go, but if there's any new stuff, and so what we've offered the cities is we've offered them to shorten their area of city impact, and we, in exchange, we will allow their ordinances to be enforced in those areas of city impact. So just another reason to, to help encourage them to let's get on the stick and do some of this stuff. The board has offered that to them, and so hopefully they'll get on the stick and start to do some of this, participate in some of this. Right now, I'm just afraid that we're going to create something, so I'd like to leave that out. There is a city impact out of the discussion.
Sorry. The second part of the statement, it's that component that got moved from the substandards. One thing I really want to mention is this is a really important component here because for DEQ, the permits for air pollution do not expire. So if somebody applied 20 years ago and wanted to apply technology that is greater than 5 years old, they could by the state. However, considering the concerns that we have for our public regarding air emissions, things like that, for their best interest, we want to maintain this clause here stating, that the best available technology within the last 5 years can only be applied. As for number 2, it stated that the process for getting new non-metallic mineral processing plants is to obtain a certificate of zoning compliance and meeting all these standards, and that they are limited only to active or to permanent gravel pits. I can change the verbiage there to take out permanent because we've already established that it could be temporary or permanent. So what I'll do is I'll put that in blue right now, and I shall cross it out.
And many times when we're saying gravel pits, because a lot of these are actually quarries. So it's not just the gravel, it's stone. So I don't know if you every place you see gravel, but if we should be putting slash.
I'm going to put surface mine so that's all encompassing.
Okay.
So let's go ahead and do that really quick.
So back to A. if we take out, I mean, the phrase now says shall be located outside city impact areas.
Now, let me take that out.
Does it, does it go anywhere? Non-metallic processing plant operations.
That might have been a typo on my part. I forgot to take it out originally.
I mean,
So let me go ahead and fix that right now.
yeah, so for not saying, that whole thing was only to say not in city impact
Yeah,
areas.
we can revisit this after we renegotiate.
So A would just deal with the emissions.
Yes.
So that best available control technology, no older than 5 years.
Right.
Who chases after them?
I believe the machinery,
So when they turn in an application for a building location permit, they provide that to us.
Yeah, that's what I'm wondering. Machine doesn't shut down in 5 years.
We're talking about the batch plant.
Well,
right, we're talking about a new application, they apply for a BLP for that batch plant.
Brand
They
new.
provide that,
brand new.
that's,
Yeah, okay, well, that's a point of discussion.
well,
That's-
you're talking millions of dollars
Yeah,
to put the upgraded, Mr. Woods has got a brand new plant there.
We're not.
No, I understand it. No, I know where you're going there, but maybe that developer has a plant, a brand new plant, but it's 10 years old. It's never put into production.
yeah, I'm not sure. I think we need to have a real good discussion with industry about that.
You can have an old plant as long as it makes the environmental quality, should be okay. And they upgrade asphalt plants and concrete plants all the time.
Yeah, and
Right.
technology changes. So
Technology changes.
So it's both who confirms that it's this or any standard. Is this another one where the county's going to rely on another state agency or whatever to say, yes, it is?
Not a state agency, it was the industry, right?
Yeah.
Well, it's kind of the same with the equipment too. I mean, a lot of guys, if we put constraints on diesel engines, a lot of these guys are running stuff that's 20 years through the application process.
Yeah.
I know, I understand. You can do what you want. It's just, it came through, this is not something we created, it came as a part of previous application.
Okay. Well, it's
That's
just
a condition on that.
It'll be a point of discussion with the industry for sure. Sure.
I mean, if it's a portable batch plant, either it's asphalt, it could be 20 years old. And it never gets used that much. It's specific for one job and then it sits idle for years. But then we're back to, but that would be the air quality could come in and say, you need to upgrade this plant. That would be on the state. You shouldn't be on the counties. Yes, that's I understand what you're saying.
So say it follows current state and federal regulations.
Right, that's where I was asking. So who chases this? Seems to be another one that's beyond the ability of the county to check. But that's where DEQ, whatever, Shaw, OSHA, they're all in there looking. And providing
So after the best available control technology as what, regulated by IDQ?
State, federal.
State, federal agency, which they're gonna do anyway. Yeah, so it shouldn't be up to us to police their.
No. I
their industry.
I'd anticipate that we would be in that realm.
It would be like telling Burlington Northern we can't have any smoking trains.
All right. Yeah.
Ms. Rodgers?
No, just that last part.
Well, I mean, A now deals, we don't have a location specific or a limitation.
Just the part. Sorry.
I was gonna write a comment.
Okay.
Yeah,
Yeah, this is already existing. This has been in existence since 2008.
Yeah.
It's just been.
But, okay.
That standard's been in the code since 2000.
It's black type.
This was the original, it's in black, it's the
Or-
original mining standard.
For the mining standard. So I don't
And we
know.
used to be a sub-note under the use table for batch plants.
Oh, interesting.
So, yeah, so maybe it is history or not. And applying that. I don't know.
This is the challenge with this.
You crack open this code and you get.
And that is what has brought on a lot of these. I have some really good planners that read this code.
Scratch their head. Yep. It's good. It's probably the first time eyes have been on it, but anyway, I don't want to disparage everybody past. Okay.
To proceed, number 3 is just asking for the approved air quality permit if it's required. And then 4 is a proposal to apply minimum setback, but there's not really any analysis, and I didn't get a response from DEQ as to what they recommended as a minimum setback. A lawyer did contact me today to say that Kootenai, I believe it's the city of Kootenai or it's Kootenai County, that has a minimum of 50 to 100 feet. But I don't think that satisfies analysis necessarily, just because another county does it. So.
And there's so many pits out there, the law of those grandfather pits that wouldn't even come close to that. I mean, some of these pits out there are only.
This is for new batch plants, not mines.
Oh, okay.
And even then, what science do you rely on to come up with a number? Noise, dust, vibration?
DEQ doesn't always apply either. So if they're not going to apply a setback, then we just say we don't need it either.
The neighbors feel like there should be one, but in various cases we start talking all kinds of stuff.
That's for batch line. Shouldn't there be a setback?
Or probably so, but what is it? What's the, I likened it to, we talked about
Well, our
sawmills and things that have motors and that have saws that have things that make noise. And the standards usually there are, you have a decreasing decibel count the further you go away, or if there's solid objects in the middle. And so you can attenuate it. But out there somewhere in the industry, there's got to be somebody's looked at it to.
Well, our code does have a standard of 70 whatever decibels for industrial.
Yeah.
Whatever it is, at the property line, so it should be set back far enough so it meets that standard.
That is.
Those standards are kind of bogus too, though, because a tractor at the property line breaks it.
Yeah. And certain uses emit sound differently. A crusher sounds entirely different from a batch plant. So, yeah.
Well, and that's my question, because you say we're talking about batch plants, but we're talking about general standards for all non-metallic. Yeah. So we're talking about screens, we're talking about crushers, we're talking about all of it.
So if we look at the one provider of concrete Ponderay, the batch plant's in the middle of that, a couple acre place. Truck pulls out, goes up out in front, they wash out, barrel's spinning away, he's still making product. And he's closer to the street. So.
Yeah. Where does that?
I mean, the batch plant puts the material in the truck mixes it up, because everybody under it.
Right. Yeah. Shades and flavors and colors.
The guys in Dover are the same way. Truck pulls out of the way, they wash out, he's closer to the street.
Huh.
I don't know. setback on where that truck's gonna mix at before he gets on the road.
I hear you.
Because they're slumping the truck right there.
Still processing.
Well, it's a process all the way to the job site, actually.
And during, and during. Keep it up, keep it mixed.
That's good.
Hey, it's gotta roll your guys' ordinance all the way back to the point. This is good stuff.
Yeah, it'll get fixed. It's gonna take time.
Okay, so you ready to jump into definitions?
Alrighty, a couple of new definitions to address our new procedure. We define certified use and certificate of zoning compliance. Basically, certified use is any structure, occupancy of a structure, use of land, certified or permitted only upon issuance of a certificate of zoning compliance and subject to the limitations and standards specified in this title. Next is a certificate of zoning compliance itself. It's a certificate issued by the planning director stating that the certified use and or development complies with the standards set forth in this title. And so what we can do is change up a little bit of that language at the end to say in this title or at the establishment.
Yeah.
Basically, we need to fix the tail end of the sentence to talk about the original ordinances, rules, and regulations.
Thank you. Copacetic with 420. Yeah.
I just want to write that down before I forgot. Then we have surface line, and we basically copied and pasted this from the IDAPA regulations. It's an area where minerals are extracted. It's a very broad definition that helps us encompass the variety of uses that are in our comprehensive plan. Again, it was suggested that we add more language, talking about blasting, drilling, and all that. So I want to talk to you guys about whether or not you feel that that's necessary, if you think the comprehensive plan addresses that sufficiently. The next part is the non-metallic mineral processing plant. This was copied and pasted again from IDAPA. We shortened the list a little bit that included like steel plants and things like that, because it didn't really apply to the actual land uses and the materials that we mine in this area.
Yeah, and even Portland cement plants. I don't think there are any in our area.
Right.
That's why it's all trucked in from elsewhere. There's not the raw material to make it here.
It's one of those situations where we decide it's better to have it and not need it than need it and not have it.
Yeah, I suppose somebody could.
But I'm more than happy to remove that if you
Well, I
wish.
just wonder if it's kind of confused.
It's not a batch wood. When people might think that. It's where you mine lime, et cetera, out of the ground and make cement.
Right. And that's a totally different,
Yeah.
What is it up? Off the tribes there? Big silos are with the Medellin Falls?
Oh,
yeah.
Where all the lime deposits.
Yeah, that's what, so then we'd have to add, silos and elevations of silos and all that other stuff, so.
I like that.
Yeah.
Well, yeah, so you're talking about Portland?
Well, yeah, Portland cement, yeah.
That's what it says.
Big silos.
Portland cement plants.
Yeah.
Big dusty.
But what we're talking about is cement batch plants.
That's what I was trying to
talk
cement that, take the Portland out of there.
Yeah.
If we had Portland here, we'd be making it.
Yep.
Right.
If we had lime here left, we'd be making it. We're not making it anymore, so I have it in the ordinance. The other thing, grind, either crush or screen, I don't know about grinding. That might be in there with the Portland cement, make it a fine powder. Might want to be removed too.
Yeah, because
there are areas in the state that would be subject to that IDAPA rule for sure. 2 or 3 places where they do have cement, Portland cement plant.
So then is this where we need to add or add temporary mines to that as well? Because it says, or any other facility or location processing non-metallic minerals from a permanent mine. But they're gonna be using those crushers and all that stuff in a temporary mine as well.
Yeah, I don't think there's any difference in temporary or permanent. It's all, equipment's all the same.
That's right.
And, the environmental hazards are all the same. So they're gonna be under MSHA, whether it's permanent or temporary.
I do want to bring up the comprehensive plan again regarding the grinding portion. In the last paragraph of the economic development, it says crushing, grinding, and otherwise preparing clay, ceramic, refractory materials, ferrite, and miscellaneous non-metallic materials that are not in conjunction with mining or quarrying operations are classified as manufacturing. If it's in conjunction with a mine, it would be a mining operation. So do we want to limit
Well,
the production of these items?
I would maybe keep it simple, and then when we get to the comprehensive plan, and we'll change the wording then.
Okay, so we want to change the comprehensive plan? Leave that
When we get
as a
there.
separate amendment, right, a separate file?
We're gonna be tweaking that whole document anyway, so.
Okay. So then we're good here on that non-metallic mineral processing plant, removing grind, Portland, and permanent?
I would think so. It's not happening, there's no reason to have. We'll get comments, where's the Portland? It's just gonna make the people just think more what's going on if it's not going on.
The next definition is open pit. This is the same as it was previously. Basically, this is an area where material has been done for use at another location and has been typically in conjunction with and close to major construction projects. So when people are doing like subdivision development or something, they got this big hill, they want to mine it off for the purposes of creating flat home sites. We're giving them the opportunity to be temporary mine so that they can, sell off that bit of material.
No retail sale.
Yeah. You just hit the buzzword. Can't sell it off.
Can't sell it off.
Yeah, temporary.
So then we don't want open pits in the county, or we allow retail sales.
It was how we worded it earlier that no retail sales is temporary operation.
Right. So my whole question was, do we want to remove open pit, or do we want to remove the prohibition of retail sales?
Ooh, that changes the complexion a
What's
lot.
the goal?
Well, I would think if they wanted, their idea was to sell that material, that they would come in and get it.
Okay, so open pit should then be under the permanent mine.
No,
Definition.
so I'm just saying that you can still have that construction site like Josh has. Josh is moving dirt on his project. It's kind of the same thing, that dirt being pulled from one area to build lots over here. But he's not selling that. We're just moving it from point A to point B.
That's just land disturbing activity.
So should it say
Not mine,
retail
not mine.
sales require conditional use permit? Yeah, instead of all are prohibited, retail sales require conditional use permit. I mean, if they want to take that mound of dirt, sell it so they can build houses, then that's what they need.
Strip off the overburden and sell it.
Yeah.
Screen it and sell it. Sell it, yeah.
at the end of that section. Last one is,
Provision.
341. There's been some lack of understanding in the past of the applicability of 1 and 2. They specifically state commercial, industrial, or public, so we wish to add letter 3, or I'm sorry, number 3, that specifically states natural resource-based, non-conforming uses. Is the nature of those types of uses is that they're always going to expand. At least in footprint and depth, things like that.
That sentence just needs to be reworked.
Yeah.
If you put a comma after that word use, how does that look then?
Community expansion of such use.
Would that contradict their reclamation plans if you just don't limit it?
Yeah.
Well, you always have to be in compliance with IPL. They definitely regulate that.
Go next door, it's not, so what the hangup is we're looking at, when we look at non-conforming use, we look at the boundaries of the parcel. But this is talking about here, this is talking about the
acquired area.
The area where it's being.
So then they've got at least 10 acres, they're chasing that vein of rock, it goes into the next parcel of 10 acres, they want to lease that from that property owner. They changed their reclamation plan.
Yeah, but that conditional use permit, and it doesn't go on to that next
Right,
property.
so they got to come back in and.
Right, or that non-conforming use doesn't include that next property.
Right.
And so, right.
But if they're chasing, we shouldn't shut them off, if they're chasing that vein. If there's already a pit there, then, you know, that's a plus for everybody to keep that mining operation.
Yeah,
right
we
there.
have talked about expansion somewhere in the code.
I don't know if it's in here anywhere else regarding mines, things like that.
Okay.
So,
I know we've talked about in our conversations about expanding up to 50%, something like that. When does it require conditional use permit?
Yeah.
A new conditional use permit.
Right. I think that's already in code. We talked about it recently.
Yeah. All right.
Can I ask one more question? I'm still going around the numbers.
I need the debate. I need
Okay.
the understanding. It helps me.
Yeah. Well, I'd come over and thumb wrestle you, but then I'd run and I can't get hurt.
I get it.
On that resource use based table, I guess where I'm having a problem or confusion, let's say, which is permanent mining stone quarries. I understand you say that's for new ones.
Yeah.
If we're going to clarify this, let's add one more line through there that says grandfathered mines created prior to, you name the date, put a C all the way across there where it says C.
That's perfect. If that helps.
Yeah.
Pardon? You better text me, I can't.
Existing?
Yeah, existing, right.
Existing.
Yeah, existing. Okay.
And it's just,
Right. Is that? Your grandfather, it's not.
Well, something to think about whether that warrants a new category.
If we're going to clarify, like we said, we don't want any, we try not to get as much ambiguity here as possible. This matrix, I mean, I'm hearing that we're going to go ahead on those grandfather pits, go ahead and get a conditional zoning compliance. But as I look at this matrix, I think it needs to be expressed better than that for me. Just in layman terms, go ahead and put grandfathered mining quarries or existing mining quarries. And instead of making them go get a conditional use permit, which I don't think we can force them to.
Well, if they've gone beyond some.
Yeah, if they've expanded, but if they're working, what's always been there, whatever, fine. Center of the earth, whatever.
Yep.
But move over 6 feet, you're in new territory.
See if the background hates that.
All right, big, long arm. Make overview, it's been reviewed, I'm sure.
So what are the commissioner's thoughts on that idea of, is the certificate of zoning compliance appropriate? Or just stating that the non-conforming use is there and just leave it alone? I'm just afraid that we leave it alone,
But, well, I've said my piece about how I think it helps, but what's everybody else thinking?
It's 10 o'clock.
Well, I hate to see a board in here 10 years from now bitching about that we didn't do it right.
Well, that'll happen
Just
regardless.
like what we're doing now, we gotta get it right.
Yeah, but is the concept of, like Nolan just said, either go through this and have this process, or just rely on the code statements now about grandfathered use?
Because we know there's a problem.
So the
We don't
concept.
have to get into that because it's in court, so.
Yeah.
There's a problem, we need to take care of it, so the guys in the room, the guys that aren't in here, they're not, on a battle 10 years from now.
Okay, any other thoughts?
Okay, we'll keep working through it. Like I said, we need to have a meeting with, outside of here, with the local guys.
Yeah.
With the public as well. Kind of like we did with the my land division ordinance, whatever.
Yeah, because there's, based on what the public has said so far, there's a lot of misconception about the extent of this and the what it would do and what it wouldn't do.
I know that it's frustrating, but it is really fulfilling. We have really got a lot done. I know that these are conversations are hard, but we really appreciate good, logical input. Like that guy tonight, he understood what we were talking about. He understood everything about it. It was a great comment. And man, we get comments like that. People understand the code. They understand the challenges, understand the possible unintended consequences.
We gotta make it fair to the public, but we gotta make it, these guys are the backbone of the country here, or the county. There's a couple people missing, but if we didn't have them in operation, we'd be deep stuff, so.
Importing everything from that other county.
Yeah, we wanna do that.
Right, the local authority. Okay. Oh, and yeah, for you guys, man, look into this, just really wring it dry, whatever. And when no one says, let's come talk, let's come talk. Absolutely. So, yeah, and all this is, regardless of what some people are saying, it's not behind closed doors.
I don't even have a door in my office.
That's right. We don't have closed doors. Even the door to the planning department was open yesterday. Totally. Stopped open.
Totally.
Okay, very good.
Sorry to cut into your sleeping time.
Yeah, thanks for coming in. And for anybody that's still on the phone, well, thank you for hanging in there on the same thing. You get a hold of the language, and the language being updated, it'll be available. So.
Are we still meeting next Thursday?
No, we're not meeting next Thursday. And it'll be announced when there'll be another workshop and/or hearing.
So folks on the line, if you're still there, keep watching the paper and the county website for further information. And thank you. and good night.
Who do I get this to?
We are.
No, my brain is not functioning.
We still have,
What I wanted to ask, open mic discussion.
Well, we can talk briefly if you
Yeah,
guys want.
very briefly. So one thing I wanted to ask you was, what's the status of the hearing examiner?
Still no application, still nothing.
Wow.
Why don't you apply for it?
Oh,
That's why you keep asking.
no, it isn't. No, it isn't.
Find somebody out there that's
Yeah.
interested.
Whoever has all those qualifications are making way more money somewhere else.
Well, I mean, retirement's a sweet thing, right?
Yeah.
Yeah.
It is. So if you lose a couple times a year. That's, so at the next, on September 3rd, we need to form the 5G committee and get started on
Oh, I
that.
can start working on my tinfoil hat. I'm gonna
We
wear
can
that.
start it. No, you get those loggers, the metal.
Is that
Metal one
committee
with
being
the
put
big
together under our
Yes,
heading? So it's the same as our sub areas. So we're gonna interview people.
yes.
Can we decline the county commissioner's request to form a committee?
We can pass a memo up, sure. I think there's only 3 so far. I'm not sure. Is that a true statement? Yeah, I figured.
Yeah, we're still.
So, yeah, I think we have 3 or 4 applicants.
So that is September,
I'm not sure.
September 3rd.
September 3rd, yeah, we'll add that to the agenda. We do have a couple files out there, maybe 1 or 2.
Okay.
Very many. September 17th will be loaded again, 5 files.
Yeah.
And then it finally starts to take off. We're finally starting to catch up from COVID. He's gonna come back.
Okay.
So we're not gonna stop meetings because now we have digital. So we won't stop meetings like we did before. That really slowed us down. Jammed us up, whatever.
You need to work on the Shelley thing, on the Shelley group and their meeting.
So I put a workshop on September 3rd agenda. If they show up, we'll see. Did they make their movie? They've not done anything.
A workshop with us.
Yeah.
Now, so
I put a workshop for at least us to talk about it.
Oh, okay, but now are we gonna, so we all know whether we're gonna be taking public input then or not? No, yay, no?
I wouldn't suspect so,
Okay.
because it's just a workshop.
Yeah, it's another one that doesn't have its own king and board. So
Yep.
I would say no.
I mean, they asked to be on that agenda, and I told them they couldn't until they did that thing, because that's what I was told, until they did their own public hearing. But in the meantime, I went ahead and put a workshop on there, just.
So do they have their thing on their website? I haven't looked.
Their plan is up. No, they did not do the video yet.
No.
They
Got the
transcript.
text of it, whatever, Fred put together, did a nice job, whatever.
So
And they've all agreed to it, so a few of them have agreed to it, saying, yep, Fred's good, you did a good job. But it hasn't been done yet.
So at this workshop, then we're not looking at any of the context, we're just looking at the procedure on it then?
We could put an action item on.
That we would be accepting it, you mean?
No.
I don't know what.
No, not to get, that's a hearing. For us to consider their stuff and say, okay, we're gonna make a recommendation to the Board of County Commissioners to.
We might have to take more than one meeting to go through.
Oh, I would think so.
Yep.
I would think so. So, but are we reviewing substance on September 3rd? Or is it more process?
That's, I guess, what I'm questioning.
I think it's an opportunity to sit and talk about this whole idea. What needs to happen next? What do we need to do? I put it there as a placeholder for them if they want to come and.
If they had done their,
Yeah.
there's no way they can do their own.
They haven't even told us, we've given them 2 dates and we've not heard from them.
It's all September. September, I'll make a motion or something, I think I call two Thursdays in a row or something, figure out off days for us at the fairgrounds.
That'd be awesome. This is kind of hairy, this not.
So let's end the meeting here. Send the meeting.
Okay. 10:15, we're off the record.
I'm taking this.
What is it? Oh, it's Dan Squirrel.
Yeah, it is.
Yeah.